Lord, may I have your lordship's leave to move an urgent motion on 10th, on Wednesday. Very urgent. The petitioner's is schedule tribe candidate. His tribe candidate certificate has been cancelled. He favored an appeal. The appeal is pending. One of the appeal is disposed of, where the order of this SDO was set aside and the certificate was said to be genuine. On 10th, 14th is the examination under the order of the court for next 2016 examination. He is an untainted candidate. Difficulty will be when personal test will come. He is to show that his scheduled type certificate is genuine. That's why I want a innocuous pair in the final pair, that let them pass on Wednesday.
My Lord, permit
Serve notice.
Yes.
my Lord, permit mention, my Lord. The similar cause of action, 3 writ petitions filed, my Lord. One has been disposed of, and another 2 writ petitions has been pending, my Lord. Monthly list, my Lord. Kindly, same order will be passed. Kindly taken up to matter.
The other matter was disposed of by this bench.
Yes, my Lord.
All right, serve notice. Urgent motion.
May I permit to mention?
Other side notice should be there.
One of the advocate served notice, another today I shall serve one.
Ensure their presence.
Yes, ma'am.
Notice will not suffice. They should be present over here.
I'm grateful.
May I permit to mention item number 906 of my combined monthly list, my Lord. This is urgent. My Lord, the petition number 2 is the citizen of Bangladesh, and petition 1 is a citizen of India. They are married. My Lord, the petition number 2 applied for conversion of the student visa into long-term visa. My Lord, if it is not granted, my Lord, if he is returned to Bangladesh, then the life risk will be, my Lord.
Why life risk?
My Lord, my communal situation, my Lord.
Where? There or here?
There, my Lord.
Let it happen. I am not
No, my
concerned.
Lord, then, my Lord, visa is equal to be extended on, otherwise, my Lord,
Sir, I am not upgrading. Yes,
he will
madam.
be harassed, my Lord.
Not upgrading. Yes, madam. What is your submission?
Your Lordship, this is for monthly list, item number 415 for upgradation. Your
For
Lordship,
upgradation?
yes,
Do
Your
not
Lordship.
mention, please.
Your Lordship, this is very urgent, Your Lordship. More than 1 crore rupees is due to the workers, but they due to puja vacation, they will be deprived, Your Lordship.
Workers means?
Your Lordship, the work has been completed according to the order given, but
Yes.
they have not been paid their liable wages.
Yes. Since when?
Since
Why did you not mention this matter earlier?
Your Lordship, this matter was taken up but was dismissed for default by Your Lordship.
So right now it is a dismissed matter.
No, Your Lordship, can has been applied.
Applied, but has it been allowed?
Yes, Your Lordship, it is in the monthly list.
Can is in the monthly list. Can is not there in the monthly list. Check up. Yes, madam.
May I have my kind lord's leave to mention a matter? My lord, the matter is appearing as item numbers 35 and 36.
Today's list.
I'm mentioning, yes, my lord. It has been fixed for hearing on 10th of September, my lord. But I'm mentioning the matter for leave to file a supplementary.
Which side matter?
List, original side, my lord.
Original side.
Yes, my
Yes.
I'm mentioning the matter for praying for leave to file a supplementary affidavit, my lord.
When the matter is called, please
My
mention.
Lord's kind leave to mention item number 122. This is challenge to the, my Lord, revocation of West Bengal Incentive Scheme 2025. My Lord, similar situation, Lordship has already dealt with 2
Give the
matters.
numbers.
My Lord, there are item 121 and 122 of today's list.
Other side should be intimated tomorrow as urgent motion.
Very grateful, my Lord.
Yes, sir.
In number 131, I am mentioning for listing the new motion, urgent motion. The urgency is that it is a tender matter, my lord. That my tender account has been freezed and I could not do nothing. My lord, kindly.
I could not follow. Tender has been allotted in your favor.
No. Yes, I am working tender.
Yes.
In the meantime, blacklisted and account has been freezed, my lord.
Nothing doing, sorry.
Yes, my lord.
I am not doing anything.
Move anything, my lord.
You cannot move. The court doesn't have time to accommodate you prior to the vacation. I'm sorry. Yes.
Urgent as an urgent motion, my lord.
One matter, my Lord, on 4th of September, my Lord, in a payment dues matter, your Lordship was pleased to pass an order by directing the respondent to release the admitted amount after 8 weeks, my Lord. Lord, my humble prayer, my Lord, before your Lordship, my Lord, one thing is left. Lord, before puja, part payment to be made. Otherwise, my Lord, Lordship, kindly
Yes.
heading to be mentioned, my Lord.
I am aware. I'm not going to change it. Give. But matter relating to
But
the
file
DM has
is lying
already
before the
taken a
party.
possession.
Circuit, they'll take steps.
Well, DM has already granted an order, but the possession of the property is not taken in the interest in favor of the bank.
DM has granted order, but then possession is not being taken. What do you want?
Well, it's to be mentioned for hearing.
To be mentioned, in to be mentioned stage, hearing cannot be done. Where is the matter?
Well, till now not in the list.
The next month, please mention.
Millet, maybe
Yes.
upon notice I'm serving, Millet, this is a matter where a lookout notice has been issued in favor of my clients. Millet, this matter was earlier heard by a lordship, wherein the union appeared and they said that there's a case pending against us and they would file a report to that effect. Millet, that report has been filed. That case which they are referring to has been quashed, Millet. Now the LOC is still pending and during the pujas, Millet, we intend to travel, Millet. Your lordship had heard this matter, Millet. Now it is not even in the list, Millet. Kindly
Come up with supplementary application. We'll see what is to be
Millet,
done.
Was heard and disposed of by your lordship on 21st August. The order has not been put into the server of my
21st August.
lordship.
Order is not there in the server. How can that be? Give the number. Check up.
Madam,
Now
mention
may I watch?
of item number 1244 of the month list. My lord, my bank account has been frozen. My lord, I'm a company, my lord. I cannot pay my workers.
Because of fraudulent transactions?
My lord,
What can be done?
my lord, kindly consider this has been ongoing for 2023. I have submitted.
Sorry, nothing doing, yes.
On 4th of September, I have been blacklisted by the authorities, despite the fact that your lordship is in ceasing of 2 pending writ petitions, my lord. But I have been blacklisted. My performance guarantee as seeking leave of your lordship.
What happened that the
But
negotiation took
no
place?
negotiation, my lord. I was just handed over a letter of termination along with my lord, blacklisting as well as encashment of my performance guarantee.
All right. So,
And then they have already issued a tender, ad hoc tender, my lord, in favor of a third party.
and what
my lord.
about that payment?
No
Nothing.
payment till date. No updation of my records, my lord, in the GST portal, my lord.
Then there is some difficulty somewhere. I do not know what is to be done. What you want?
I'm praying for your lordship's leave, my lord, to file this writ petition. If your lordship kindly takes up this matter on Friday, my lord.
Fresh
Writ
one.
petition, my lord.
All right, give.
Grateful, my lord.
Yes.
My lord, for upgradation, the petitioner is 94 years old.
94 years old.
94 years old bedridden patient. His savings account, credit card, all account has been hacked from Axis Bank Howrah branch. So once cyber chief has been arrested for the accused person, only 2,50,000 has been recovered. But the respondent banking illegally claiming money from petitioner and petitioner illegally claiming the petitioner against hacked and expired credit card.
Yes.
Already petitioner has been admitted in hospital. I have
Yes.
serving urgent motion.
Where is the matter?
846 monthly list.
Give notice to the other side. Friday it will appear.
Okay, much obliged.
My lord,
846.
my lord, may we
old man, my lord. My lord, the urgency is this, my lord. An order has been passed by the SDO, my lord, under the Senior Citizen Act, my lord, whereby, my lord, my brother and my sister has dispossessed me from the, my lord, from my property, my lord, and all the belongings has been occupied by my brother.
No, but then SDO must have passed some orders.
My lord, SDO has passed the order, my lord. My lord, SDO has directed to go before the civil court, my lord. Now,
Yes.
my lord, I am staying in my relative's
So
house, my lord.
prefer an appeal. DM is there. Why come up before this court? Yes.
Your lordship's kind leave, my lord, to mention a matter for, my lord, upgradation, my lord. This is that Aadhaar card matter, my lord, where this, my lord, Aadhaar card is not being updated because of mismatch in the birth certificate, and my lord, because of that, my lord, KYC is not being done.
What is to be done?
My lord, this is for upgradation, my lord. That, my lord, called for a report by the union, my lord. They have given us a report, my lord.
Yes.
Be praying for an upgradation, my lord. It can be, my lord.
Very difficult.
Lord,
The prior to the vacation, it is absolutely difficult. You give the number and serve notice Friday. Let us see if it can be done. Friday. Yes, madam.
This is a restoration matter to complete the trees. So the business was totally hampering, and due to some circumstances, my
First is restoration.
yes,
You were not present when the matter was called.
because my seniors in the other court. So
Yes, so you should know which matter is how much important and steps should have been taken. Right now, matter will not be enlisted.
Item number 1339. The petitioner is a primary school teacher. He has been assigned the duty of a booth level officer. The petitioner father is the cancer patient. He had to attend his father for chemotherapy, and his mother is bedridden. He is the only family member in the family, my lord. If your lordship kindly take up this matter, I file an application
No.
for exonerated duty, my lord.
Yes.
My lord, may I have your lordship's kind leave to mention this is item number 20 of your lordship's today's list. Item number 1, effectively under the heading adjourned motion. My lord, your lordship heard this matter relisted today. My lord, my difficulty is that I have not been allowed to enter, despite there being a verbal direction by your lordship, despite there being a written order that all the arrears, if your lordship kindly remembers the matter.
I cannot remember. It's absolutely impossible to remember so many matters, right? It is there in the list. Please do not mention.
May I have your lordship leave to mention a matter under the application head, your lordship, for inclusion on Thursday?
No,
your
sir.
lordship?
Nothing. No inclusions prior to the vacations. Yes, sir.
Your lordship, restoration application, your lordship.
No,
kindly
nothing
file
doing.
it
Yes,
in
please.
I'm junior of Mr. Dindamila. That's
My lord, may I be permitted to mention, my lord?
Just because it is a passport matter, lordship.
Nothing doing. Sorry.
My lord, may I
Yes,
permit
call
to
the
mention,
list.
my lord, there is an application seeking inclusion, my lord. It's only for clarification. This is an order passed by your lordship concerning section 14, my lord, of the South Asia.
Clarification after the vacation. Let the confusion remain now. Yes.
My lord, for item number 1, I'm appearing for the petitioner, my lord.
But on the last occasion, your lordship asked whether the interim order was.
Who is this person?
My lord, I am unable to, my lord, switch on the video, my lord. I am appearing online, my lord, on behalf of the
আমাদের বাড়ি
ভিডিওটা কেন অন হচ্ছে না?
Last occasion, your lordship asked whether the interim order, which was passed by the Honorable High Court, has been extended or not.
This matter?
This matter.
Alright.
Kindly see the order, my lord. Your lordship will remember everything, my lord. Because
yes, Andhra Pradesh has been extended. Extension was not placed before this court.
Yes. Now,
My lord, I beg to appear, my lord, on behalf of the respondent number 9, my lord, on the last occasion, my learned junior had also appeared, my lord, that we didn't have the Vakalatnama executed. My lord, it has reached us now. My lord,
what is the matter? I have handed over. Now, my lord, the learned counsel who is representing the government in that High Court, now, my lord, he has given a mail to us, my lord, before that, that the interim order is subsisting, although matter was directed to appear.
Stay is still in force. September, we shall update it, and when the case is listed, stay is still in force. There must be something in writing. It cannot be oral order that stay is in force.
The learned government leader who has been appointed, my lord, he has sent this mail to us. They are because they are the person.
Over there, the court's orders are not uploaded.
Well, that has not been uploaded. Whatever uploaded, I have filed on the last occasion also, my lord. But before that, now kindly remember, my lord, the matter.
30th of July.
30th of July, my
We are in September.
30th of July, matter was supposed to appear, matter did not appear. Now, my lord, verbal
And
mediation.
what does the last order say?
Last order, my lord, in
Particular date
status quo.
till?
Status quo, initially the interim order was granted.
My lord, may I just intervene once? My
You
lord,
are for the petitioner?
I'm for the petitioner. My lord, the interim order, what my learned friend is saying, my lord, I have a soft copy of it which was sent.
Yes.
It's on my phone. I'm not able to get it.
Say, read out.
My lord, it says interim order granted earlier extended by 4 weeks. List the matter on
Date.
20.
Date of the order?
My lord.
4 weeks. When does it take us to?
My lord, the date is not mentioned.
Then 4 weeks, how will you ascertain when does the 4 week come to an end? Date of the order must be there.
No, this is my 26th day of June 2025.
June, 4 weeks is long over.
My lord, subject to my lord, your lordships, my lord, kindly leave, my lord. May I make one submission? My lord, we will file the Vakalatnama. And my lord, there was a direction for filing of affidavit as well. My lord, will grant us a week's time, my lord, to give everything on order, my lord. This is my only prayer. My lord, take it up on weekends, my lord. I'll come back with the instructions, my lord. I'll find out from the, my lord. I have a counterpart in the Andhra Pradesh High Court, which I have just contacted today morning. My lord, I will take instructions, my lord. I'll come back and apprise your lordship.
My lord, on the last occasion also.
What is the matter, my lord? I'm telling you, Lordship.
No, matter is regarding fraudulent transaction or something.
My lord.
But that's what happened, your lordship knows in terms of the Registrar General circular. If we find, we have to intimate, my lord, the local police or the local court, my lord, and the court directed the refund of the money. Now we communicate to the bank. Bank, my lord, is not cooperating. Thereafter, we filed application that we have communicated to the state bank. Subsequently, my lord, matter again transferred to another account. They filed a writ petition in the Andhra Pradesh High Court, and their status quo order was passed. Now, in that writ petition, my lord, the entire transaction money is lying over there. Now, that's why your lordship was pleased to ask my lord, my learned friend to add as a party. Now, they have initially they choose not to appear. Now they appear.
Yes, petitioner, what will be your submission?
My lord, on the last occasion also, the respondent number 9, through his learned advocate, was present, and then after my lord was pleased to submit that he has no instructions.
Yes. I completely, my lord. This is fact, my lord. In fact, my learned junior, my lord.
Representing the respondent number 9.
My lord, the affidavit of service may be kept on record.
He has received the Vakalatnama very recently and intends to defend the respondent number 9 in the instant proceeding. Stop. Prayer has been made to allow a week's time for filing the opposition. Stop. Learned advocate representing the state respondent submits upon instruction that the status quo order passed by the Andhra Pradesh High Court is still in force. Stop. Copy of the said order has, however, not been placed before this court. Stop. Release the matter on 16th September. Stop.
My lord, the other submission, my lord, I had one submission, my lord. This is, my lord, where, my lord, the writ petition, my lord, a prayer has been made. My lord, the respondents are all should be, my lord, within the original side jurisdiction. My lord, otherwise it goes to the appellate side of this honorable bench only. Perhaps, my lord, that is also something that needs to be looked into.
That argument has been made. Your lordship said it will consider later on.
The order of the High Court shall be placed before this court on the urgent date.
But kindly ask them because they are the party also, my lord, the respondent number 9. They can also, my lord, supply.
Yes, they will
No,
bring.
we will take instructions, my lord. We'll come back to this.
Report filed by the
Report filed by the officer in charge, Posta Police Station, dated 8th September 2025, be written with the records. Next.
Willful be your lordship.
16th September, na?
My lord, the affidavit of service may be kept on record.
Yes.
My lord, may I be permitted to mention on behalf of the bar, my lord?
Yes.
My lord, our senior member, my lord, ex-president, Jayant Banerjee died yesterday, my lord, that we have taken resolution not to pass any order in absence of any of the parties, my lord. The Bar Library Club also taken same resolution.
All right. Yes. 2.
Well, this your Lordship, on the last petition, I was supposed to submit a report. So, the corporation is concerned when I'm submitting a report to your Lordship.
What is the matter?
Sir, this is regarding a writ regarding fire safety measures in
Yes.
a multi-storied building. Well, the fire department had conducted two inspections and has filed two reports. Various glaring exceptions are noted in that report. Now, there was also one point that had cropped up that how in a completely residential building, trade license have been issued by Kolkata Municipal Corporation. That's where Mr. Ghosh had intervened and had sought to file a report. Today the report is before your Lordship.
Give a copy so that they also get to know.
Report and come back. There was a
Alright.
direction to circulate. There was a direction to circulate. I've got a copy now.
What does the report say? Is there any
My lord, that is a residential, no doubt about that. And when the building plan was sanctioned, that commercial shop, a small area was permitted to be in the ground floor. Then, my lord, certain other one of the diagnostic center was open. So, on the first floor, in respect of that, a proceeding was initiated. And ultimately, your Lordship's direction in separate proceeding, my lord, separate proceeding. The proceeding was ended, and your Lordship directed to consider and dispose of that matter, my lord, that was disposed of. And so far as that is, my lord, one, my lord, the diagnostic center on the first floor is concerned. Now, my lord, we have ascertained later on, my lord, as many as, my lord, 25, my lord, the license has been obtained by different persons.
25 licenses in a residential building?
Different natures of business. Although, my lord, all the businesses are not being run at the present moment, and I have, my lord, got it from the welfare of the corporation of the license department. And, my lord, my lord, after ascertaining this fact, my lord, there may be necessity for, my lord, initiating a proceeding, because if there's someone, my lord,
So who is stopping you? Why don't you initiate proceedings?
No, that, my lord, I have ascertained in course of this proceeding. Otherwise, I could not have known, my lord, because all the persons are not running a business there at the present moment.
Thing is, your persons do not go there to verify whether somebody is running a business or not. Thing is, on record, there is a business.
Not, my lord, running is not there, but operating license, my lord, in future.
How can, why don't the first thing that I saw is that licenses are issued online. Why don't you have a mechanism by which you can understand that this is a residential building and commercial license cannot be granted? You can update your software in such a manner.
You know, I appreciate this thing, my lord. This question, my lord, number of times, my lord, even for consideration. The license department, whenever the category of the building is not, my lord, looked into, my lord, they personally, my lord, whenever it comes to that, my lord.
Sir, this is the query of the court. Why don't you update your system so that you get to know that this is a residential building and there is, you cannot grant any license over there. It is just a matter of technicalities that you can do it.
Looks at the permission, my lord, if somebody, my lord, intends to carry on business, my lord, on the basis of that, my lord, a particular premises is, my lord, allowed the running of the business. It is up to the person concerned.
The report of the executive engineer, building department. Borough? Which borough? 2. KMC filed in court today is taken on record. Stop. Let copy of the same be circulated.
Lordship kindly grants us liberty to use an exception.
Why? Who are you?
I'm the respondent number 12, madam.
You are running the business over there.
I have one of the commercial units.
And you have restaurant.
I have submitted all my permissions. I have used an affidavit to the previous report which was submitted.
All right. And you have your permissions and everything in place.
Everything, all the up-to-date license I have annexed.
All right.
Everything is on record.
Then why will you file an exception to this? If you have your own case,
liberty, because I had to take instructions.
Take instructions. See, check up what is there.
My lord, I'm for respondent number 10. I also have the commercial. I am a tenant of the landlord who is paying the commercial tax to the KMC regarding the operations of business that is going over there. So, my lord, I also need to file an exception regarding that with a new affidavit. I have already filed one regarding respondent number 10 regarding the license that I have presently, and also the commercial tax that I am
released on 10th of November. Exception to the report may be filed by the parties prior to the adjourned date.
May I make one submission?
Yes.
My lord, this is regarding, my lord, the commercial use of a premises which is residential. But the writ essentially is for, my lord, compliance of firefighting equipment in a high-rise building. But there is every threat, that anything can happen any day. But just to cut the matter short, the developer
Is the state there? Who
State
is for the state?
developer
State is not a party?
Yes, state is a part. But the developer who was
Yes.
supposed to do all these firefighting equipments to be installed in the premises, that was his obligation, has filed an affidavit in this read saying that yes, these are my obligations, and if the honorable court gives us some time, I will comply.
Please take down a further order.
But if so, that's why since they are not here today, if your lordship fixes it one day before the vacation, and this can be done for the upcoming pujas because it's a gap of at least 2 months before November. Based on that, show your lordship the
The
undertaking. that-
fire and emergency services is directed to ensure that no unauthorized business runs from the said premises without obtaining permission from the authority.
Lord, kindly seize this one.
No, nothing. Next.
The matter will be appearing on 10th of November.
Yes.
Grateful.
May I have leave to put in a supplementary affidavit? Here, my lord, we had obtained adjournment. This is, my lord, relating to a tender issued by the Port Trust, where, my lord, we had participated. And, my lord, there were certain issues regarding possession, and there were certain issues regarding, my lord, execution of lease. Now, we have, my lord, we always wanted to, and to show our bona fides, we have made all necessary payment, including sums, my lord, which we say are not claimable from us pursuant to the tender documents. My lord,
possession has been given. Well, the only issue, if your lordship recollects, where there was an addendum in respect of which they were required to make payment to the private respondent in respect of the structures and the buildings. So now they have taken repeated adjournment. Now they have paid, and we have also given possession. So so far as the present writ is concerned, nothing survives. Your lordship can dispose
it
it.
does. Not insofar as Mr. Bose is concerned, but insofar as the Port Trust is concerned, it survives.
I am the Port Trust.
Oh, I'm
I
sorry.
appear for the Port Trust.
It does, my lord. There are two issues, my lord. One is municipal tax and the rate, and the other is, my lord, GST on municipal tax, which is, my lord, contrary to law. Now, the tender documents, my lord, only say that.
Then your lordship has to allow me to use an affidavit. This cannot be
I
decided.
have no objection.
Your objection will not do. Was that the challenge in the writ? Let me see.
Yes. Prayers F, G, and I.
It is their tender. They will decide whether it is to be done or not.
No.
And you participate in the tender process. You have
Yes,
been
so,
given
Lord,
possession, paid money.
I am not, my lord, I am not going contrary to the tender documents.
Then what is the issue?
My lord, if your lordship sees, my lord, prayers F, G, and I.
F, G, and
my
I.
case is simple, my lord.
Quashing demand made by the such and such in the allotment letter for payment of occupier share of municipal tax. Municipal tax will be paid as per the
my lord, tender documents, my lord, tender documents say levies in accordance with law.
Absolutely.
Subsequently, my lord, we have no objection to all levies in accordance with law. Subsequently, they call upon us, when we are, my lord, L1, they call upon us to make certain specific payments. We say that those are not in accordance with law because there is no GST on municipal tax. And you can't, my lord, charge at the rate at which you are charging. Your lordship's pleasure was, if you are bona fide, first pay. We pay without prejudice. And, my lord, we come back before your lordship. My lord, we'll proceed. My lord, we'll have the leases executed. We've made all payment, including those disputed. Let them use an affidavit.
Now, what about the GST on the municipal tax?
On the structured GST, that is the understanding between the divorce garage and the petitioner.
Yes.
That has been that
I've
we
paid
are
everything.
Not, we are not concerned.
You're not. He's
We are
not concerned with that.
And you with the divorce garage is a private matter.
I am not. That is there in between them.
Yes.
I am not charging GST.
I am on
and the
GST.
municipal charges, as per the act, we are charging 40%. Supposing the charge is 40% on Port Trust, 20% has to be paid by them, and 20% by the Port Trust. And so for the Howrah Bridge is concerned, 5%, 0.25 and 0.2. That we have charged.
But the point is
because in terms of the agreement between the Port
municipal
Trust and the
corporation.
KMC, Our charges is like that.
Municipal corporation
And
is
whatever
not
the
charging.
statutory charges, we cannot take in our pocket.
That's the point.
Show me that they are charging anything beyond the statutory charges.
No, that is my assertion. They
Hey.
have to show that, Milord, this is the charge.
No, you say how much they are charging and how much is it liable to be charged.
230, Milord. Section 230 of the Kolkata Municipal Corporation Act, Milord.
Yes.
And Milord, they, according to them, they are paying 40% municipal tax on, Milord, the land rent which I am paying them. According to me, Milord, that is not correct. Their calculation is allegedly they are paying 40%.
Listen, the
plus
corporation will give a tax receipt to the port trust, and from there you'll get to know. So it's a matter of record.
I have no problem.
Entirety agreement with the port trust and KMC. Whatever the charge tax is 40%. On 40%, we charge 20%.
Whatever is the statutory.
Sir, may I just indicate one thing, my lord?
Lord, I have paid in advance. You just show my lord the receipt. I will withdraw the return walk away. But you, I have asked them 5 times
Just
to
wait.
give it to me.
Yes.
Initially, they say registration was
Please
not there.
wait. Yes, Mr. Bose.
My lord, may I just indicate one thing, my lord? Lord, Section 171 of the Kolkata Municipal Corporation Act, subsection 7 of Section 171, which is recorded in your lordship's last day's order when Mr. Mukherjee was appearing on behalf of the petitioner. My lord, that contemplates that in respect of port properties, there is an exclusion of applicability of the general provisions of the Kolkata Municipal Corporation Act for the purpose of assessment of annual valuation and payment of tax. So far as the port authority lands are concerned, there is a contractual arrangement between the KMC and the port authority in the year 1950. Based on that, there is a formula which has been arrived at between the parties that based on the annual rental value, the tax component will be 40% of the total annual rental value.
See, 1 minute. Whatever is chargeable according to the act, please
paid
do it.
the lessee and the remaining half
I am disposing of the writ. Nothing remains for.
The only thing is, I am ready to pay at rate charge.
Please come.
Milord, may I just have 1 minute, Milord?
It has been brought to the notice of the court that the petitioner has
7th August,
made the
25.
necessary payment and possession has been handed over to the petitioner. Stop. Paragraph. The petitioner raises an issue with regard to the municipal taxes charged by the port authority.
And
Stop.
GST on that, Milord.
The petitioner also raises an issue with regard to the GST on the municipal charges that have been levied. Stop. Paragraph. The port trust authority is directed to, not directed, will be obliged to charge the tax from the petitioner strictly in accordance with the act in question. Stop. The writ
According to the
petition.
agreement between the KMC and Kolkata Port Trust. That is
There is an act.
That is statutory. That
There
is
is an act.
statutory.
In accordance
yes.
with law. In accordance
That is
with law.
statutory.
The writ petition stands disposed of.
Grateful.
Next.
And Milord, may I just ask for one indulgence? Milord.
And my lord, lordship kindly records the fact that we have handed over possession
He
to them.
asking for proof. What is the
No, I just.
Every tenant I have to give them proof. Every tenant, total land I have to pay
I'm
charges.
not asking
Not the subsumer.
Milord, whatever is, Milord, the justification for the levy, they should provide to me. That is all that I am asking for.
Whatever, you can always put in a query.
I have already provided.
Yes, next.
Challenge it. Well, not only one indulgence. Well, not kindly record that possession has been handed over by us to them.
Yes, sir.
Yes, that is
so this
fine.
was one of the. Well,
that's been recorded.
Great.
I just keep the supplementary on record.
Copy.
Now the dispose of they are given supplementary.
It's required. Because the court has not looked into the supplementary.
I'll tell you, Lordship, what it has. It contains specifically the fact.
No, but then the court has not considered it. So you keep it with you.
Yeah, well, yes, well, great.
For
respondent note.
Association. Where is the petitioner?
The Silver Spring
Association.
I am for the state respondent, my lord.
But
In
there's
this
nothing
matter,
beginning in the writ. They wanted a competent authority to consider it and dispose of their complaint.
Is the petitioner there?
We've received the notice. No, he's not.
Appearing for another flat owner and seeking to intervene in this proceeding. But if the petition.
Anyway, not today. Not today.
Item number 5.
Lord, this is that CAB matter, my lord, where I requested for an adjournment on the last day to reconsider. My lord, I went through my lord's order, which my lord passed. I also, my lord, went through the Supreme Court judgments. My lord, actually, we have no other forum but your lordship. Please permit me to, my lord, explain.
I'm appearing for the respondents in this matter, your
Which respondent?
lordship, the Cricket Association of Bengal, the respondent number 1, your
The
lordship.
principal respondent.
Lordship, the principal respondent. I'm being led by Mr. Joydeep Kaur, your lordship. Lordship kindly grants me a note today.
Not today.
Grateful, your lordship.
Hi, of course.
Okay. Chalo.
My lord, in this batch of writ petitions, there has been a death of one of the petitioners, my lord, last Friday. My lord, item number 11 of today's list, my lord,
Why
Sundarlal.
has my video been blocked?
That, my lord, the petitioner has died.
You have to come up with a substitution.
My lord, this is, my lord, in terms of that circular issued by the Reserve Bank of India, it's an action in personam.
Okay.
So, my lord, death would really.
So nothing remains against
Nothing
him?
remains against him, my lord, according to me. Item 11, Sundarlal Dugari.
If because fraud, the person is.
It's an action in personam initiated by banks and financial institutions.
Who's declared as
in
fraud.
terms of the, my lord, master circular.
All right, the others he can.
Others he can, my lord. I just wanted to indicate this.
All right, all right.
Willful default.
Willful default or fraud?
Willful default.
But I just give a quick recap as to how far I have submitted. I have taken your lordship, my lord, through the show cause notice. I have shown your lordship the definition, my lord, so far as willful default is concerned. And I have shown your lordship that in their reply, as per the definition, my lord, they have admitted 3 things. Number 1, my lord, there has been transfer to their subsidiaries and associate companies. And my lord, the figures are all admitted. Number 2, the only issue which they raised was there was a change in name, mistake in name. These were the 2 issues. 2 names could have been spelled out better. And number 3, my lord, they say that though there has been transfer, it is in the nature of strategic investment. And I have shown that strategic investment is not an exception. And there is nothing on record to show that my clients had permitted them to make this investment. And my lord, so my lord, whether you say it surreptitiously in your balance sheets or not, my lord, that is neither here nor there. Because my lord, as per the definition, they are admitting that I have transferred. And my lord, that's all I am required to satisfy in terms of my lord, regulation 2 of the RBI circular. Then my lord, I had shown your lordship so far as the complaints with regard to, my lord, the formation of the committee. I had relied on a Telangana High Court judgment that it is not a prerequisite that in the order I have to mention I have to disclose the composition of the committee members, especially, my lord, in a case, my lord, where they chose not to appear. And, my lord, I had also, because they had relied upon action ishpat, my lord, I had shown the division bench judgment of our court, my lord, which has impliedly overruled, my lord, that provision. And, my lord, I made my submission that principles of service jurisprudence has been borrowed in. That the test is really whether the authority has taken the decision. Who is communicating or who is signing, that is not very material. Now, my lord, apropos that, my lord, since... Oh, to me, what judges? My lord, apropos that, since I have shown your lordship, my lord, the division bench, my lord, later a single bench of our court also, my lord, has followed that division bench, and my lord has, my lord, kindly have a look at This is reported in 2020 SCC Online Calcutta 1659. I remember this judgment, my lord. I had myself relied upon action Ishpat, and my lord, I was caught by surprise by, my lord, then Mr. Rai was, my lord, on this side. Lord, Lordship will kindly see para 6. Perusal of the judgment reveals that the writ petition succeeded on the sole contention advanced on behalf of the writ petitioner that the identification committee required to be set up in terms of 3A of the master circular had not issued the show cause notice to the company as well as the writ petitioners, and notices issued from the regional office of appellant number 1 without any authority of law vitiated the entire proceedings. Lord, I am not troubling your lordship, my lord, with the rest of it. My lord, kindly straight away come to para 18. 18, 19 and 20. There can be no doubt that the master circular has been introduced to check siphoning of public funds by borrowers who, in opinion of lender bank, despite having resources.
Sorry, I think the paragraph number is not telling.
Not telling with mine as well. I think yeah.
Sandeep Kumar Bajaj, are you relying upon?
I am sorry, my lord. I am very sorry. Yes, my lord, I made a mistake.
Sudhir Kumar Patodia porche.
I am sorry, my lord. এটা আইপ্যাডে কোনটা ঢুকিয়েছো বলো তো?
Sandeep Bajaj is there.
Sandeep Bajaj. My lord, I am relying on. I am sorry, my lord. I was reading Sudhir Kumar, my lord, by mistake. My lord, the marking has gone wrong. I'll come back. My lord, kindly come to paragraph 7. I am sorry, my lord. Very
yes,
sorry.
yes. Yes.
I'll first deal. My lord, is it matching now?
Yes, yes.
I'll first deal with the preliminary issue, which is that any proceedings initiated against the petitioner as guarantors. My lord, guarantors, I need not trouble your lordship. My lord, kindly straight away come to guarantors aspect, my lord, as of now is not there. My lord, kindly come to paragraph 10.
Yes.
The question which would arise is whether the post of deputy managing director mentioned as the head of the appropriate committee in the impugned notice is equivalent to that of the executive director under 3A of the master circular. The stress on equivalence would be justified from the use of this very expression in clause 3A, which allows a loosening of the composition of committee by prescribing headed by an executive director or equivalent, underlined for emphasis. It is also significant that the show cause notice clarifies that the composition of the committee or the departure from the recommended composition is as per approved by RBI. It is also significant that clause 3 of the master circular slackens the rigor of the requirement by using the expression should generally include the following and puts the stress more on a pyramidal power structure of the committee of a head who is ranked higher than the 2 senior officers of the rank of GM or DGM who form the base of the structure. This court also takes judicial notice of the fact that there are presently no executive directors of the Board of State Bank of India, which is comprised of a chairman, managing directors and directors. As on 7 September, the Board of Directors of SBI comprised of a chairman, 2 managing directors, 2 shareholder directors and 2 nominee directors. The State Bank of India Act also does not contemplate a post of executive director. Therefore, the first contention with regard to improperly constituted committee under a deputy managing director fails. Well, this I am only showing because of the limited interpretation that it slackens the rigors of the requirement. This is the first observation. Then, my lord, comes the point which we are directly involved with. Lord, paragraph 11, I need not trouble your lordship because it is, my lord, yes, my lord, para 11, my lord, I should place it. Appropriate committee, yes. The next issue is of the appointed committee not applying its mind or making such non-application evident in the show cause notice, thus rendering it vulnerable. Clause 3B starts with, if the committee concludes that an event of willful default has occurred, thereby implying that the condition precedent to issuing a show cause notice to the concerned borrower is of the committee forming an opinion on the basis of available evidence as to whether there has been a willful default under clause 3A. The petitioners contend that the impugned notice is devoid of any indication that the appropriate committee has indeed done what it is supposed to do under clause 3, namely apply its mind to the materials which would identify the petitioners for the purposes of show cause notice. For assessing the worth of this contention, the impugned notice should be seen against the mandate of 3B. While it is correct that the first page of the notice is opaque in terms of making the workings of committee's mind known to the petitioner or recipients of the notice, the lacuna is addressed by annexure to the notice stating the justification or reasons for declaring the borrower as willful defaulter. The accompanying tabulated statement lists the criteria for classification as willful defaulter as per RBI Master Circular dated 1st July, with further reference to the events of defaults and evidences and documents substantiating each event of willful default. My lord, Lordship would recall here also, my lord, there is, my lord, not only, my lord, the definition, but also, my lord, 6 companies were identified, the amounts were mentioned, and so far as the amounts are concerned, all accepted that these are correct. Only minor variation in the names. It should also be mentioned that the respondent has furnished a resolution of the Willful Defaulter Identification Committee dated June 17 in relation to the company, which contains a proposal for approval of identification of willful defaulters and issuance of show cause notice. The resolution further encloses, my lord, the agenda is there. My lord, kindly straight away come to para 12. In this background, the questions which would naturally arise are, my lord, is it necessary for a show cause notice to disclose the basis of conclusion arrived at by the committee under clause 3A? And if yes, how can such application of mind or formation of opinion be made apparent on the face of the show cause notice? My lord, the second issue is what we are concerned with, because here also, my lord, reliance was on the Atlantis judgment. My lord, kindly come to paragraph 14. Well, 3A and 3B has been paraphrased in para 13, para 14. In the facts of the present case, the contention of the petitioner of the impugned notice being devoid of any indication of application of mind by the committee is not acceptable on 2 grounds. First, the master circular does not require it, and more important, the annexure to the show cause coupled with the resolution of the committee dated 17 June provides sufficient material and particulars specified to the company of which the petitioners are guarantors to satisfy that committee had indeed fulfilled its mandate under both subclause A and B. One of the most obvious ways in which working of the mind or some sort of deliberation by the persons concerned can be shown is by articulation of the findings arrived at with reference to a meeting including of minds where such deliberation palpably took place, and the findings being relatable to the materials or evidence before the committee entrusted with the duty to sift through the evidence to come to the conclusion. Now to the decision cited in support of the arguments advanced. Atlantic Projects, decided on 3rd May 2019, was on a challenge to a show cause notice in which the petitioner had contended that the functioning of issuing of a show cause notice cannot be delegated to a person who is not a member of the identification committee. The learned single judge held that an identified administrative authority cannot delegate its power to issue a show cause notice under clause 3 of the master circular. The finding in that case was that the identification committee must apply its mind at all stages to the materials before it arriving at a conclusion pertaining to willful default, and further that the borrower described as the delinquent in the decision must have the entire material that was before the identification committee for the purpose of giving a complete response. The division bench judgment in Sudhir Kumar Patodia and Pavan Kumar Patodia, well, this is the division bench judgment which I had shown to your lordship, pronounced on 28 February 2020, was also concerned with a challenge to a show cause notice on the ground of improper constitution of the identification committee and non-application. On the ground of improper constitution of the identification committee and non-application of mind in classifying the writ petitioner as a willful defaulter. The division bench construed the RBI guidelines and held there had not been any delegation of the functions of the identification committee, as the power only involved identifying a willful defaulter, and a final order in that regard would have to be made by the review committee. The decision proceeded on the basis that identifying a willful defaulter is essentially a fact-finding exercise followed by an administrative decision. So, my lord, now it is well settled. It's a fact-finding exercise and it's an administrative decision. And that is why, my lord, principles of service jurisprudence has been borrowed in the division bench decision. The division bench accordingly was of the view that regional office of the appellant respondent being delegated the task of issuing the show cause notice would not by itself invalidate the proceedings which have been initiated under the master circular for declaring the petitioner as willful defaulter. Relying on Secretary Ministry of Defence versus Prabhash Mirdha, it was additionally held that a show cause notice, well, this is show cause notice doesn't give rise to show cause action. Well, I am not on that, I am on the first part. Then, my lord, kindly come to para 16. The decision in Pawan Kumar Patodia is relevant for the present case for the following reasons. First, the challenge mounted to the show cause is on the same plank, namely that the issuing authority lacked jurisdiction under the governing guidelines and that there had been delegation of power to a lesser authority. Second, the aspect of a decision having been taken by the concerned committee, implying application of mind to the material at hand, was considered by the court. The court, however, held that omission to refer to the decision of identification committee would not render the show cause notice vulnerable to challenge. Third, the question of prejudice consequent to a show cause notice was addressed by the division bench, and it was held that the purpose of such a notice was to make the charges known to the borrower so that it could give a comprehensive explanation to and defend the same in the form of hearing, etc. Besides this, Pawan Kumar Patodia is a later decision compared to the single bench decision in Atlantic projects and considered the same issues which were canvassed in the latter. It is significant in Pawan Kumar Patodia, the division bench refused to interfere with the show cause notice, despite finding that notice was issued by an entity not prescribed under 3A of the master circular. The fact that division bench was also of the view that show cause notice need not reflect the decision taken by the concerned committee effectively takes care of both points urged by the petitioner in this case with regard to clause 3 of the master circular. It should be pointed out that division bench considered State Bank of India versus Jha developers and expressed its reservations on the decision being of assistance to the writ petitioner respondent before the division bench. The conduct of the petitioners, as would appear from the facts of the present case, would further lend credence to the prejudice point as considered in Pawan Kumar Patodia, or in other words, whether the petitioners have suffered any prejudice by issuance of the impugned show cause notice. The scheme of clause 3 of the master circular, mechanism for identification of willful defaulters, contemplates a two-tier system of identification where the decision of the first committee under clause 3B would be subject to review by a second committee under clause 3C. Hence, no finality is attached to the decision of the first identification committee, and more so at the stage of a show cause notice. Further, the petitioner in this case received the impugned show cause dated 14 November, together with annexure on 18 November. The date of receipt would appear from reply of the petitioner dated 19 December to the show cause. In the said letter, the petitioner contended, inter alia, that the appropriate committee had not been formed in keeping with RBI guidelines and called for withdrawing of the show cause notice. The respondent bank thereafter issued a notice of personal hearing dated 17 July upon the petitioner to appear before the willful defaulter identification committee for making appropriate submission. The petitioners were given the option to make submission through video conferencing on a specified date. On receiving the notice for personal hearing, a chain of correspondence followed between the petitioner on 28 July, whereby the respondents asked the petitioners to be present for the personal hearing on 17 July, to which the petitioners requested to keep the meeting after August due to prevailing lockdown in the state. The petitioner sent another email on 29 July to the respondent that it would be inconvenient for the petitioner to attend the personal hearing. This was followed by a reply from the respondent attaching a copy of the revised letter for personal hearing dated 6th August 2020, by which the petitioners were given opportunity to make their submission through video conferencing before the concerned committee on 24th August at 12:15 p.m. The present writ petition was filed on 17th. From the trail of correspondence, it is evident petitioner were initially not averse to appearing before the concerned committee for making their submissions with regard to the impugned show cause notice. The reason given for the petitioner for inability was the pandemic, and petitioners requested for the date. The correspondence indicate petitioners were not averse to a personal hearing per se. A few decisions have been cited on behalf of the respondent whether an improper act or decision can be cured by subsequent ratification. Since this court is of the view that there was no defect in the act of issuing, this is not three principles emerge from this judgment. Number one, my lord, besides now expressly recognizing that Atlantic has been overruled by reason of the Sudhir Kumar Patodia decision, my lord, the second judicial notice taken is, my lord, the import of service jurisprudence so far as this is concerned. And third, my lord, lordship will find even in this case, they, my lord, they were given notice. Physically, they did not appear, but they made a representation which was considered. An order was passed, and my lord, they thereafter review committee. Again, my lord, I have shown your lordship the tenor of the representation and an order passed. Now, my lord, so far as the identification committee, I have showed your lordship, my lord, that one of the signatories was a member of the committee. I have already shown your lordship. Now, my lord, kindly take the review committee order. My lord, first, if lordship takes the affidavit in opposition.
Which page?
Well, at page 29. Well, I am making my submission from the Manoj Toshniwal writ petition.
Yes.
Right?
Yes.
Because well, that was the main matter, and in the other matters, there were factually one or two variants. One was the guarantor, one was a corporate guarantor, and one says that I was not a full-time director or promoter director. I'll come to that, Millard, shortly. Millard, page 29. And my lord, this document was criticized, my lord, when the petitioners made their submissions that this is being disclosed only in the affidavit in opposition. That is why, my lord, I started with those judgments that all that is essential here is that whether the concerned committee has applied their mind. And my lord, when that is, my lord, on record, my lord, nothing further need be looked into, especially, my lord, in the background of the prejudice test. My lord, the prejudice test was also applied in Sudhir Patodia. That these are the guidelines, this is what you have admitted, and I have shown, my lord, the bullet findings in the first committee also. Shri Rakesh Sharma, MD, CEO, Chairman, then, my lord, Samresh Parida, Independent Director, and PV Bharti. And then, my lord, the rest are not concerned because, my lord, one of the identification committee members, my lord, Murli Sauri Rajan, was also present in that. My lord, he was also presenting because the views of the identification committee. Then, my lord, kindly come to the next page, page 30. The WDRC deliberated on the memorandum dated 5th March seeking to review and confirm the order passed by Willful Committee to declare the promoters and erstwhile directors and guarantors, so-and-so, so-and-so, and so-and-so as willful defaulters in terms of the RBI circular and report to the Credit Information Committee. It was submitted that the company is under liquidation through NCLT. Hence, it was excluded from the willful defaulter declaration proceeding. After discussion, the WDRC passed the following resolutions. And my lord, lordship will find only the operative portion of the resolution was passed. And my lord, at page 31, last two paragraphs. The concerned CGM is authorized to sign the reasoned order of the events of willful default committed by the promoters so-and-so, that the dealing group is authorized to communicate the above decision of WDRC to the promoters and erstwhile directors and guarantors of guarantee. And my lord, this is signed by the chairman. So, my lord, chairman in a resolution, only the formal part is, my lord, signed. authority is granted that this. Now, my lord, kindly come back to the writ petition, the decision which was, my lord, of the review committee. My lord, kindly come to page 542 of the writ petition. (542) it starts. I need not trouble your lordship, my lord, with the entirety. Kindly straight away come to page 547. Towards the bottom, lordship will find that heading observation of WDRC, that is Willful Defaulter Review Committee. It may be mentioned that the related party transaction between a parent and its subsidiary joint venture shall be made only on terms equivalent to those that prevail at arm's length transaction, and such terms shall be substantiated. Proper disclosure of any related party transaction between a parent and its subsidiary or associates or joint venture may be required as per applicable accounting standard to enable users of financial statement to form a view about the effects of related party relationship on an entity. That the investment made in the subsidiaries or other corporates are borne out of the audited financial statements. Well, pausing here for a moment, this is exactly, but in their language, they are admitting that your own representation is showing that money has flown to your subsidiaries. And that is the definition of willful default, well, as per the RBI circular. In any manner whatsoever, if money goes to your subsidiaries or to your associate companies, that is, my lord, one of the events of, my lord, siphoning off. That is the definition which I showed to your lordship. Merely intimating the financing banks about such related party transactions may not absolve the company from directors of their liability to adhere to accounting standards. Same is in violation of the terms of sanction. With respect to the argument, my lord, maximum cap of 20%, my lord, same observation that there is no such, my lord, they were unable, even the petitioners were unable to show, my lord, any rule or, my lord, any terms of the sanction that there was a cap of 20%. That has not been argued also. So if it is not argued, that is why, my lord, I started my submission that on merits, my lord, there is no argument that these findings are factually incorrect. So, my lord, as of now, since it's a repetition, I skip over, my lord. Kindly straight away come to page 552, paragraph 12. General submissions from promoters, erstwhile directors, and guarantors. These are in the 3 letters. These were, I had already shown your lordship. And now, my lord, kindly come to observation of WDRC, page 554. Lord, I am just reading this. Sunita Bardia, my lord, when I come to the writ petition separately, I will show. My lord, she was not only a guarantor, my lord, she has signed a subsequent document, my lord, when the terms were extended. And that, my lord, they did not disclose. We have disclosed it. It may be mentioned that Sunita Bardia continued to be a personal guarantor in the account, and IDBI never agreed to discharge her from her liabilities as guarantor for the entire credit facilities availed by the company, and she has acknowledged the same by signing acceptance in the sanction dated 20th October 2017. Further, as an existing guarantor, her liabilities were coextensive. My lord, and I shall show, my lord, that this is not in dispute, that she has signed this document. Then, my lord, kindly come to the paragraph 2. It may also be mentioned that bank has duly constituted the Willful Defaulter Committee, and the Willful Defaulter Committee order and show cause notice of 11th were issued under its direction. The bank has followed all mechanism for identification of willful defaulter as stipulated in RBI circular. Then, my lord, DG that for in-house proceedings, my lord, lawyers not, my lord, required, my lord, that is now well settled. Now, my lord, kindly come to page 555. Conclusion of WDRC. After noticing all this, my lord, these are the conclusion. Based on the above mentioned facts and analysis, WDRC of the opinion events of willful default were committed. My lord, this is the operative part which was signed in that minutes. My lord, these two conclusions, my lord, where the chairman of the review committee signs it. And then, my lord, is the order at page 556. The WDRC carefully examined the contents of written representation received in response to the order and observed that the written representation have not brought out any new fact, law, or material that has to do with changing the decision of willful defaulters committee of the bank to declare them as willful defaulter. The responses does not comprehensively cover all the ground on which proposal for declaration as willful defaulters. My lordship would recall those 7, my lord, tick marks which were the decision, and this is, my lord, that. And my lord, the order is affirmed. And now, my lord, kindly come to the last page, 557. By the order of willful defaulters review committee, my lord, Subramaniam is signing it, who was authorized. Lordship will find. By the order of willful defaulters review committee, because, my lord, in the minutes, this gentleman was authorized. And I have already shown, my lord, the Telangana High Court judgment, which recognizes this is possible. I have also shown, my lord, the jurisprudential justification, my lord, so far as the ratio of Atlantic being overruled, my lord, by the Patodia decision, and, my lord, how the principles of service jurisprudence comes in. So, my lord, if I may sum up, my lord, 2 facts are evident. Number 1, that, my lord, in their representation itself, my lord, they have admitted that the facts are such that it otherwise qualifies under the definition of willful default. Because, my lord, there is admission that money has gone from my company to my sister concerns or my subsidiaries. This is, my lord, the first admission. Second, when the facts are admitted, 2 technical grounds are taken. Number 1 of the identification committee. I have shown your lordship, my lord, that has been signed. And number 2, so far as the review committee is concerned, my lord, the signature in the reasoned order is not of any member of the review committee. That is, my lord, primarily the allegation. My lord, I have already placed the decision that once, my lord, it is shown that it is the decision of the committee and this is by the order, my lord, pausing for a moment. Had they any doubt, my lord, they would have asked that, all right, you show us how the review committee had authorized them. We would have forwarded the minutes. But only thing is, the allegation is the minutes have been disclosed in the affidavit in opposition for the first time. And, my lord, that, my lord, I have already relied on the Telangana High Court judgment. And, my lord, of course, I have shown the ratio of Patodia and, my lord, the subsequent judgment. Now, my lord, this takes care of, so in my respectful submission, my lord, the reply itself is in the nature of a judgment upon admission. Lordship would recall I had started my submission in that way, that I don't have to go any further. In your reply, you are saying I have transferred money to that. It's a strategic investment. And I had also said that all transfers are treated to be strategic because you are investing in shares while you are taking money for something else. You are not taking money from the bank to invest in shares or in your subsidiaries. Well, that is not their case. And, my lord, the 20% cap and all that, my lord, I have already dealt with. And, my lord, in the identification committee order, the 7 findings which are in bullet points and cryptic, none of those findings have been challenged over there. So once, my lord, the identification committee rightly exercises its power and the review committee affirms it, saying that there is nothing new over here, my lord, in my respectful submission only on technical parameters that signature has not signed, my lord, lordship would not be pleased to exercise, my lord, the jurisdiction of judicial review. My lord, this takes care of the Manoj Toshniwal matter. My lord, so far as the next writ petition is concerned, my lord, lordship will take up the other one. Factually, my lord, there are slight differences.
So the constitution of WTC, does it require, because they...
So far as the constitution of both the committees are concerned, lordship can take it from me, my lord. It is as per the RBI circular, it is disclosed in our affidavit. And, my lord, they were not present, my lord, over there. They can't say that The order does not say, therefore it is presumed. I have already, that is why I have relied on the Telangana one. But kindly take the WPO 520. This is the case of Biplab Kumar Bose. Eta koto item koto?
6.
Yes, well, at item 6. Well, in this, the only contention that was raised was Biplab Bose was not a promoter director. Therefore, he did not take part in any of the financial decisions and he had resigned.
He had resigned.
Yes.
When?
This is, my lord, the sum and sub. I'm sorry, my lord. Resignation is another one. Here, my lord, the only defense is he is not a promoter director. He admits to be a director, but not a promoter director. This is the only reason. My lord, the answer to that is, my lord, and we have said that, my lord, for the purpose of this, my lord, lordship will have to take the balance sheet. My lord, he is a signatory to their balance sheets, and lordship will find that balance sheet, my lord, in WPO 675. My lord, kindly have a look at volume 2 of WPO 675. My lord, they did not disclose the balance sheets here, but inadvertently one other petitioner have disclosed it. So, my lord, this factual background itself will take care of their entire submission. My lord, kindly come to page 172, 171 and 172. Six, 7, 5 is not a Biplab, but my lord, I am showing this only to, my lord, kindly see 171. Lordship will find in the balance sheet on the right hand side, my lord, lordship will find 2 signatories. Manoj Toshniwal, that's the previous writ petition, chairman cum director, and Milord Biplab Shankar Bose, director. So once you sign the balance sheets, you cannot say that I was not a part to the financial decisions and all that. And my lord, apropos the RBI circular, my lord, it defines unit to include individuals. And my lord, the definition is wide-ended in the sense that individuals associated with the company would all fall within the definition of unit. So my lord, other than this, and my lord, he has taken a plea that he was not in a position to attend the personal hearing. He has admitted that at page 8, para 18. So my lord, opportunity was granted, but the other defense on merit was, my lord, similar. This was only the additional ground that I was just a technical director. I was not involved with the financials. Lord, that is factually incorrect. A signatory in the balance sheet, my lord, in law, he is presumed to be involved with the financials because you are certifying for on behalf of the board. You cannot, my lord, approbate and reprobate. So, my lord, this takes care of the writ petition of Biplab Kumar Bose, which is, my lord, yes. Yes, my lord, is initially he says I did not receive it, but subsequently, my lord, I got the notice. So, my lord, to that effect also, my lord, there is no, there cannot be any issue. But, my lord, the main point highlighted was in respect of this was that he was not a promoter director. He was not involved with the financials. He was a technical guy. That was the, my lord, argument advance. So this, my lord, I have shown by referring to the balance sheet. Now, lordship will kindly come back to the next writ petition. Let 521, which is of MKN Investment Private Limited.
Which page? MKN page?
Yes, my lord. In the writ petition, kindly come to, my lord, page 4. My lord, there are 2 admissions. Number 1, admitted position that MKN was a corporate guarantor. And, my lord, number 2, there is admission that MKN was served twice and MKN admittedly received the notice, my lord, at the second instance. My lord, page 4, paragraph 10. By a letter dated 11th August, respondent 2 informed the petitioner about a personal hearing before the Willful Defaulters Committee. On a perusal of such letter, it transpired that a purported show cause notice dated 9 January was allegedly issued, calling for an explanation from the petitioner as to why the name of the petitioner should not be included in the list of willful defaulter as per Master Circular on Default published by the Reserve Bank of India. The said letter dated August 11 was served on the petitioner as an attachment to the email of 14th August. It is pertinent to mention here that the letter dated 11th August indicated that it was the second opportunity of personal hearing before the Willful Defaulter Committee provided by the respondent authority. But in fact, the petitioner had not received prior. So, my lord, he says that the second. Now, my lord, para 11. Your petitioner was shocked to receive the letter dated August 11. Petitioner is a corporate guarantor to the credit facilities advanced by the consortium lenders to the principal borrower. By a notice of 27, my lord, 13.4 has been pleaded. And my lord, the only ground pleaded is that whatever asset is there in 13.4, other than that, they have no other asset. So therefore, it cannot be said to be a willful default. But kindly see para 13 now in this background. In the above background, page 5, para 13. In the above backdrop, the petitioner did not respond to the letter dated 11th August. However, letter dated August 11 was followed up by further letters of 7 November by which further notices of personal hearing were issued. So, my lord, elaborate and repeated opportunities was given of personal hearing. They did not. And then, my lord, when they received the order, my lord, they are shocked. But other than this, my lord, there is nothing special about this because factually, my lord, it's a. And my lord, once you admit I am a corporate guarantor, liability being extensive, my lord, even the guidelines, I shall come to that last, my lord. This is, my lord, so far as MKN is concerned. Now, my lord.
Today we are going to stop here. It's
Yes,
12.
yes. I'm sorry, my lord. I'm sorry, please.
Sundarlal has expired. This has been brought to the notice today. 11 petitioner has expired.
This a copy of.
Please come. Death certificate.
My lord, it's
Death certificate.
My lord, it's a Department of Anatomy certificate saying that the body was taken. We don't have the death certificate as of now in our position.
The last line, last sentence records original death certificate has been kept in Department of Anatomy and may be produced as and when required under law. Donate
I think so.
Has been donated.
Correct.
Body was donated. That's why the original has been kept.
Learned advocate for the petitioners have brought to the notice of the court that Mr. Sundarlal Dugar, petitioner in WPO 675/2024, has expired on 5th September 2025. Stop. The certificate issued by the Department of Anatomy for my Institute of Postgraduate Medical Research, Medical Education and Research, dated 5th September 2025. Produced in court today, be retained with the records. Paragraph. One more day will be enough for you.
Yes, 10 more minutes.
And you can make the reply on the same day.
There are bunch of matters for item number 6, my lord. I will be in some personal difficulty. Your lordship will hear Mr. Mukherjee in the other matters.
All right.
Because up to 18th, I will be in personal difficulty. I will not be coming, my lord.
Then the vacations will
19th, I can give the reply. I will be just adopting an additional point. I will
yes,
be.
so let them conclude it more or less.
My lord, I can be.
More or less.
As far as Mr. Mukherjee is concerned, my lord, I have been told that for him also, my lord, any day after 18th. So if, my lord, Mr.
Any day after 18th?
18th September, there's That is what it's for Mr. Mukherjee, because if you're
Let it remain, my lord. I take 10 minutes, then thereafter.
Your portion will be over
At
there
least, my lord,
after the
otherwise, my lord,
reply.
there is a regular, my lord. I am quite
Yes.
worried because I also want to
Me
get
too.
this out of my system once I.
True. The learned counsel representing the respondents continues with the arguments. Let the matter retain its position in the list.
Lordship, deeply.
এটাকে রাখবেন।
Sir, only one thing, my lord.
এটাকে রাখবেন।
Next matter, I was also praying, my lord, Mr. Bose is on the other side.
Next
That
matter means?
Item number 13, Anupam Industries.
From 6 to 11.
Yeah, 12.
My
lord, Mr. Bose was replying that award by the MSME Council is a nullity. That also, my lord, kindly keep it after 18th. I will not be in a position.
Today I'm not passing any order. When it is called, then
My
please,
junior, my lord, will.
somebody should make me aware.
My lord, 11 has been disposed of by your lordship. Sundarlal Dugar.
It has not been. Next day, formal order will be recorded. I have kept the certificate on record.
Deeply.
My lord, item number 1, I appear for the petitioner.
Yes.
I beg to appear on behalf of my lord, respondent numbers
My lord,
11 to 15.
On last Monday, your lord.
Respondent numbers?
11 to 15.
Private respondents.
My lord, in this matter, my lord, I have taken out an application, my lord.
I see the application.
Yes, seeking extension of the, my lord, stay order passed by the Honorable Division Bench in this matter. My lord, in this matter, what had happened, your lordship, by an order dated 23rd of June, was pleased to direct the wetlands authorities, my lord, to demolish the alleged illegal construction and to restore the wetland. My lord, an intra-court appeal was preferred. The Honorable Division Bench, my lord, was pleased to stay the order passed by your lordship for a period of 6 weeks. That apart, my lord, threefold directions were issued to exchange affidavit. Time period was also fixed. And my lord, liberty was given to me to seek for extension of the stay order before your lordship. And my lord, liberty was also given to me to address your lordship on the point of maintainability, since my lord, I was able to demonstrate before the Honorable Division Bench that they have approached your lordship, my lord, with absolutely unclean hands and by suppressing material facts, particularly, my lord, with regard to, my lord, pendency of a civil suit, my lord, apropos the same property. My lord, I admit that there has been a delay of 2 days, my lord, in affirming the affidavit in opposition. My lord, I am seeking, my lord, your lordship may kindly, my lord, extend the stay order.
What is the civil suit?
My lord,
Declaration and permanent injunction.
That they have, my lord, completely suppressed, my lord, in their affidavit in opposition. Which
What thing?
My lord, the petitioners. My lord,
What has been suppressed? The suit?
Yes, and the rejection of the ad interim order.
Tell me whether it's a wetland or not.
Yes.
My lord, this has been classified, my lord, in my most humble and respectful submission as, my lord, a rural urban settlement. There are 3 classifications. In the event your lordships, my lord, may kindly take the
Your DAG number and your plot number, everything is mentioned?
Yes. It's a urban settlement area, my lord.
All right. So it is not.
My lord, in my humble submission, my lord.
A water body completely.
Yes, my lord, there are 3 classifications.
Who's for the today? Nobody is there for the state.
My lord, Mr. HON'BLE Sen, my lord, was appearing on.
All right.
Wetland authorities.
Mr.
Sen. This is the copy of my supplementary affidavit. Kindly see your lordship's last order. My lord, they have violated the interim order by making further construction. My lord, these are the photographs and my lord.
Yes. Circulate copies to Mr. Sen and to the other authorities also.
Yes.
Who are the other authorities? The wetland authority must be a party.
Mr. Sen is appearing for all.
He is appearing for all. Then you have to give a copy to him.
My lord, I can.
Yes, please do. Where is the plot number mentioned?
Lordship kindly takes up the prayer of the writ petition.
Is it page number 6 of the writ petition? Absolute owners of all that piece and parcel of wheel, mat measuring 5 bighas, dag numbers 9, such and such. Find out from that book. You've got that book?
Yes, Jagadipota.
The chart.
Entirely within wetland.
Mauja Jagadipota.
Yes.
All right, circulate, please come.
Milord, I'll request your
Supplementary affidavit.
I have objection, Milord. They have violated, Milord, the order passed by the Honorable.
Filed by the writ petitioners in court today is taken on record. Stop. Learned advocate for the petitioner submits that the private respondents, in complete violation of the direction passed by the Honorable Division Bench, is continuing with the work of construction. What is your submission? Are you making construction?
No, my lord.
Milord, there are photographs, Milord. Kindly take the supplementary affidavit. 12 to 14.
12 to 14?
Yes, page number. In the midnight, last Sunday.
The petitioners have annexed photographs in support of the submission that the unauthorized construction is being carried on at the night time. Stuff. Next. None represents the official respondents. Stuff. The learned advocate representing the private respondents. No, learned advocate, no. The private respondents have filed an application seeking extension of the order of stay passed by the Honorable Division Bench. Stop. Released the matter on 16th September. Stop. Learned advocate representing the official respondents shall apprise the court as to whether any construction work is being carried out at the subject place. Let this order be communicated to the learned advocate representing the official respondents. Stop. The issue of extension of the stay order passed by the Honorable Division Bench shall be taken up for consideration after obtaining the report from the official respondents.
Good.
Next.
Number 2.
None appears on behalf of the petitioners. Released on 15th. Next.
For the petitioner.
Yes, please. What is the matter?
But that foreigners matter. But kindly seize the last order. They have not complied the order.
Not complied. What was to be done?
But they were supposed to intimate us the formalities and the assessment fine amount.
Please call up Miss Rashmi Bothra.
Lordship.
Is she there online? No? Please call her up.
Okay, my lord. She was present.
She was present. See whether she is outside or not.
Lordship.
Call her up.
Lordship. Wait.
Next.
Milord, I am appealing for the petition.
Yes, please.
Milord, this is the supplementary affidavit, Milord, which your lordship directed my client to file, Milord, disclosing the documents which have been denied.
Cancellation of the scheduled tribe candidate.
Yes, yes.
What were the documents? Let me see. Dekhi.
First one, which one is that? There are two matters. Pehla wala kaun sa?
Sumit Shaw.
Abhijit Shaw.
Where is your other side? Nobody is present.
Nobody is present.
Did you serve this?
Yes, my lord. First one is Sumit Sai. All right.
Show me Sumit.
Sumit.
Page 9, nothing can be legible from here.
Page 9 is a photocopy. It has been typed at 9A.
All right.
Part A, prepared in 1948. Electoral roll. The name of his grandfather. Great grandfather.
How can the councillor of a Kolkata Municipal Corporation issue SC/ST certificate? What knowledge does he have? Can he issue?
Whatever the documents which we had produced.
I understand, but then you have relied upon something which has no relevance.
Yes, maybe it may not be, but I have disclosed these are the documents. 1948 electoral roll, when at serial number 5, my great grandfather's name is.
Please come. Supplementary affidavit filed by the petitioner in court today is taken on record. None for the respondents. Stop. Release the matter tomorrow. Learned advocate representing the state respondents shall make submission with regard to the documents annexed to the supplementary. Give a notice. Let this order be communicated to the learned advocate representing the state respondents.
In both the matters, similar direction be given.
Call, let us see whether the respondent is present or not. Same counsel was there?
Yes, yes.
Oh, then same order. Yes. Same order.
I appear for the petitioner.
Yes.
Lord, Mr. Bose is appearing virtually. He's leading me. My lord, this is the application filed by us, my lord, challenging the holiday listing of the petitioner entity, my lord. We had mentioned the matter in the last week on the ground of urgency because, my lord, till 28th of September, the petitioner has been suspended. His account has been suspended in the GEM portal, which is the government e-marketplace, which is the respondent.
I am for IOC yet.
Mr.
Jem is
Bose,
really the answering respondent.
Lord, we have the affidavit of service. We have completed the service on both the respondents. Lord, Mr. Bose, I see, is joined.
If GEM's presence is required?
My lord,
Jem has issued the order which is impugned.
On
my complaint.
My lord, on their complaint, my lord, the GEM, which is the portal.
If the complaint is yours, then the matter can proceed with you.
Yes, it can, my lord. It can, my lord. What basically GM has done is that, my lord, on the complaint of Mr. Shuddha
Yes,
Shatta
I have
Banerjee's client, they have suspended.
Yes.
My lord, I'll tell you, Lordship, my lord, in short, my lord, the facts are undisputed. My lord, the portal, which is, my lord, the government e-marketplace, my lord, it, on behalf of all public sector undertaking, floats tenders. So, my lord, the subject tender was also floated by, my lord, GEM, which is the government e-market portal. My lord, if you kindly takes only one clause, it will become clear, my lord, what was the scope of the work. If your lordship kindly takes page 72. It was for fire detection alarm system. I had to maintain this fire detection alarm system, which is the scope of the work. If your lordship will see at page 72, towards the middle of page 72, item category. And my lord, immediately below the item category, lordship kindly makes a note. The contract period is for 2 years.
Yes.
Now, my lord, I'll straight away take your lordship to page 323. Lordship will kindly take the trouble of coming to volume 3, which is page 323. Well, the contract period was for 2 years, which was awarded to me I successfully completed the 2-year period, which is, well, if your lordship will see the time of completion at page 323, job description, then completion period. It says 24 months from date of handover of site with a provision for extension of the contract for 12 months more on same rates, terms and conditions of the contract on sole discretion of IOCL. Well, now, apropos this, will not kindly take once the immediately a few pages thereafter, page 340, 340. And my lord, kindly, my lord, this is the letter of acceptance issued by Indian Oil Corporation to me. My lord, kindly take clause 5 at page 341. Clause 5 at 341. Lord, please note that the time allotted for carrying out this work is 24 months from the date of handing over a work site. The contract period may be extended. My lord, kindly make a note of this, my lord. Clause 5.
It is the same thing that was there in the initial
Yes,
page that you showed.
I'll tell you. Now, my lord, what has happened is this is the letter of acceptance by India. So everything turns on this clause, which is clause 5 of the letter of acceptance, which says that the contract period may be extended by another 12 months or part thereof under same rate and terms and conditions on sole discretion of IOCL, Haldia Refinery, on satisfactory performance of the contractor. So, my lord, if I satisfactorily perform, they will have a discretion if they want to extend it. Now, my lord, the extension can only happen. I offer to pursue the or I make an application or I make a request that you extend. Only then it will be the discretion of Indian Oil Corporation to extend. But the contract period, the valid contract period between the parties was 12 months, which has come to an end. Well, now this is where the problem starts. Well, immediately after the completion period was over, well, Indian Oil Corporation calls upon us to say letter of extension, my lord, to extend the period by a period of 12 months. That your lordship will find at page 366. Without me requesting, Indian Oil unilaterally extends the contract by a period of 12 months.
Yes.
There is no acceptance from my part. If your lordship will see this, page 366, the first paragraph of the letter.
But page,
This is-
the contract, the clause number 5, does it not say that it will be extended on the sole discretion of IOCL?
Correct, my lord. But I have to request for the extension.
No,
There cannot be a
not
if your lordship will
necessarily.
see, the contract period is 12 months. Now, my lord, the extended period is beyond the period of contract. The discretion is with an Indian Oil Corporation. Like if your lordship is aware of the landlord-tenant leases, the discretion of extension of the lease would be with the landlord. So that doesn't mean that if I give an extension, that the extension will be bound upon the contractor. You cannot bind me. I don't want to avail of the extension. I don't want to work anymore with you. I have done my 12 months. I have done the 24 months satisfactorily. You have accepted my satisfactory work for 24 months, and you want me to work for a further period of 12 months, which I am not interested. So,
What is
there
the
has to
issue?
be a
Please tell me.
No, that is the issue. Because I don't accept the extension, they have suspended. Well, this is so fundamental. Well, in the contract law, there has
Yes,
to
an
be an
offer
offer
and
and there has to be
acceptance.
an acceptance to make it a valid contract. Now, I am telling them that I am not interested. I cannot. I don't want to work with you. Well, you cannot impose and say that you have to work during extension. And well, this is the ground on the basis of which a complaint is lodged by Indian Oil Corporation with the GEM portal, and GEM portal proceeds on the basis of the complaint and suspends me. Well, I'll tell you, just give your lordship a few more pages. Here, your lordship will find, your lordship has already seen paragraph 1 at page 366. Well, on the
Yes.
basis of this, I write to them, I give a response to them. If your lordship kindly takes my response, which is the 1st of April at page 382, the relevant paragraph your lordship will find at page 383, the third paragraph at page 383. At page 383, the third paragraph. This is my response to their letter of extension. Although we, as a successful service provider to your plant, expressed our difficulties to continue with the contract after the original contract completion period in all our earlier communications. And the same is again mentioning that we are not at all in a position to extend the contract as you requested. However, as a very special case, we will continue AMC service against the same contract for an extension of 3 consecutive months from the date of the original 24 months contract closure, provided all pending bills are getting processed. Well, that's a different issue, whether I have been paid or not. I don't want to bring that up. Now, on the basis of this, your lordship will kindly consider there is a complaint that has been lodged by them because I did not accept this. That your lordship will find. I'll straight away take your lordship to the complaint and the suspension. Your lordship will find the complaint is at page 442. At 442, well, this is from the GEM portal. Your lordship will find incident responses. Just a few lines after that, there is a sentence starting towards the middle of the page. GEM admin sent show cause on 10th June 2025 addressed to Glyptic. Glyptic is the petitioner before your lordship.
All right.
Which one? So, Willard, thereafter, Willard, kindly take page 443, the second paragraph, original contract terms and conditions. Willard, kindly see the last sentence. Vendor is denying the extension. Willard, 443, second paragraph, last sentence, vendor is denying the extension.
I did not get it.
Well, at page 443, there's a paragraph starting original contract, original contract terms and conditions. Then it says at the end, vendor is denying the extensions. So what is the outcome? Well, kindly now come to page 451. I am suspended from 14th August to 28th of September.
Yes.
So this is the document which is under challenge before your lordship. You cannot enforce. There is no breach on my part.
Please show me the portion 451.
451. Well, the first sentence, can you see? Your account has been suspended. This is the reason of suspension.
Just below incident responses at 451, the first sentence. Your account has been suspended. Has your lordship? My lord, at 451, incident responses in the middle of the page, just below that, GEM admin took action on 14th August, addressed to Glyptic, my lord. Below
Your
that,
account
your account has been suspended from 14th August.
The interesting part is, why I'm asking for an interim order. All tenders, all public authority tenders are through this GEM portal. I can only participate if I am allowed to the GEM portal. You have suspended me. Now I have already lost out on to apply in 23. In 23 tenders, I have not been able to participate. So by the end of the month, I will have no work for the coming 5 years. And for what? Because you are forcing an extension upon me, which I'm not interested to. Well, this is the limited condition. This is the limit. Lord, can I take your lordship's kind leave, my lord? My
Yes,
junior
yes.
is there, my lord, if there is any.
Certainly.
If I may just respond to that.
Yes.
Lord,
You do not have an issue if they are permitted to participate in other businesses, not yours. You do not want them.
No, that's the whole thing. I'll just show to your two documents to your lordship. And what is the importance of IOCL? Two aspects are completely glossed over. The complaint is not just limited to the fact that he's not executed the work. First, a tenant-landlord analogy is given to say formation of contract. I have to agree. Just two documents I'll show, my lord. Please have a look at the completion certificate once, which is at page 446. But while your lordship looks at it, I'll just indicate what is the nature of job that they do and why this clause is there in the contract. Please have a look at page 446.
No, but then you cannot stand in the way of they working with somebody else.
No, so
You
that is
can
why
always restrain them from working with you.
I want them to work for me. So that is the distinction.
No, they are not interested. You cannot force them to work
No,
for you.
that's right. So what happens is when you're doing on GEM portal, which is why GEM's presence is necessary, I'll show the GEM guidelines. There are different categories of breaches.
Yes.
There is mild, moderate, and serious. Why this has been considered serious has been glossed over. Look, with every time a contractor or a tenderer is appointed, he has to give us the list of laborers. He has to naturally
He
comply
doesn't
with
pay the
PF
provident fund and other dues. He did not pay.
He does not.
All right.
Also, he forges these ESI documents and he submits to me.
All right.
These are 3 complaints which are filed on the GEM portal.
Are those
That is
appearing?
considered, yes. That
from
part
the
was not
records
placed. Not one aspect I'll just indicate. Look, what happens here, if let us say this room is the refinery. I have a refinery. Along the room or the refinery runs these fire lines, which has nodes which identifies whenever a fire occurs, that node gets activated and there is water pressure or some kind of a controlling mechanism that is immediately setting in. These nodes is maintained by this petitioner. In all our contracts that we enter into because of this, because of the seriousness of the job, the tender itself says that it will be 2, and if I'm happy with your performance at my discretion, I'm going to extend it by a year.
No, but then you cannot force somebody to work for you.
I cannot. But then, when he accepts it, then that's a breach. Because his letter of acceptance, I'll just show that, that part was not shown to your lordship, saying that there was no acceptance. Please have a look at one thing, Please have a look at his letter of acceptance. This is at page 340. This is what he consents to. Now, when it happens through GEM portal, I am under an obligation to intimate any breach or breaches. That breach is then considered and a show cause notice is issued. In this case, also the entire proceeding has been done. I'll show that. But please have a look at this first argument that there was no acceptance. This is his letter of acceptance to my tender. He participates on this basis. He accepts it on this basis. This is his letter of acceptance.
Acceptance?
Yes.
Is that? Yes.
2 + 1 at my behest. That is his acceptance. That I can, at my discretion.
You can choose not to extend the contract. That is your discretion.
Those are his terms of acceptance.
Yes.
I would not have given it to him had he participated saying, I am not giving you this discretion. Because for me, he accepts the tender and gives the letter of acceptance saying, I'll do it for 2 years and I'm accepting your discretion to increase it by a year. He can't get out of it, which is why he says that I'm going to give you for 3 months. Now, the other aspect of it. Please have a look at the complaint.
Yes, please.
I'll just, Lordship will have a look at 451 and I'll show the regulations here. Why he has been suspended is for all 3 counts. Plus his 8 RA bill, I'm carrying that document, his 8 RA bill, he does not give the particulars. When we ask for it, he forges documents and he submits it.
Please show page 451.
Page 451, your lordship will see.
Yes.
Description, deviation in contract obligation, terms and conditions, time of completion of the job, failure to execute the contract as per the original terms and conditions for a further 1 year on same rates and terms and conditions. 2, no reply received on payment of wages to workers engaged in the jobs. No document related to ESI of submission of PSI, EPF, ESI is submitted to EIC. GEM is requested to take suitable instruction. Then what happens? GEM admin takes step 14th August. Your account has been suspended. This is much later. Not immediately under that, your lordship will find show cause notice was sent to the vendor, that is him.
No, but then there, 1 minute, 3 descriptions in the deviation portion is there.
Yes.
Right? Not
Yes,
3,
but
in fact 2.
Just
Deviation
immediately after that,
contract.
lordship will see Devashmita Panja, buyer, added a comment. Show cause notice sent to the vendor on 23rd July.
Yes.
And the reply by the vendor is not satisfactory.
Yes.
Following are the reasons for holiday listing of the vendor. Deviation in contract terms. 2, no documents related to submission of PF ESI submitted to EIC. 3, after issuing show cause notice, seller submitted forged and edited PDF files. Admin is requested to provide list of documents required from buyer end. Now your lordship will see annexure 4 duly. Now I'll show the regulations once. Lordship will have a look at the regulations of the GEM thing. Why this has been considered as a serious? There are different offenses that are there. Your lordship will find the final order, post the show cause, a reply, my reply, this is considered by GEM, and your lordship will find that it refers to this particular clause. I'll just rely on that, just place that clause for your lordship's kind consideration. At the top, your lordship will find incident responses immediately after 451. At page 451.
Yes.
At 451, incident responses.
Right.
GEM admin took action on 14th August addressed to petitioner. Your account has been suspended from 14th August to 28th September due to non-compliance of service level agreement, unsatisfactory performance against the service contract. The value is more than so-and-so. Clause 2.2 II. In view of the raised incident, the buyer has uploaded the decision in the requested format. Hence, as per management policy, action is taken. Now, kindly have a look at what is this 2.2 II. May I just hand it over?
Yes.
How much?
I have one over here.
Very well.
Yes. Is it applicable from 25th of November 2024? Very first page. Very first page at the middle.
21st of July 2025.
Oh, then that will be the latest one.
The 2.2 II, your lordship will just have a look at once. Incidents.
Which page is it?
Page 5 of 25.
Page
At the
5 of
at the
25.
bottom of the page, my lord,
Yes.
find the incidents not verifiable through data available and on the portal. Incidents that require subjective decision based on information available with buyer, seller, and consignee. For such incidents, buyer, which is me, will have to first take internal approvals of the competent authority on the issue under dispute incident reason. Then buyer will raise the incident on GEM and escalate it. Show cause notice shall be issued through the seller to the seller, which will be visible in their dashboard. The reply of the seller received on the SCN will be first evaluated by the buyer organization. The buyer will submit the seller response to the competent authority in the buyer organization and take approval of the competent authority on the issue under dispute or incident reason. The decision of the buyer's competent authority on the issue will be uploaded on the buyer on GEM dashboard in reply to the comments of seller and SCN. The uploaded document must clearly indicate 1, 2, these are different reasons there. Then your lordship will see the competent authority has decided to seek an action against the seller for the incident reason. Final action by GEM admin will be taken only after uploading of the competent authority decision on the GEM portal. Buyer organization which shall responsible for defending the action taken based on buyer recommendation in such cases. Format of competent authority's approval to be used as per so and so. Now your lordship will just once have a look at the different types at page 7 of 25.
Yes.
There is an incident reason, clause 2.2. Then there's a column to the right, and there are 2 columns. For debarment, buyer specific. Serial number 2, your lordship will kindly make a note of. Delay in submission of statutory compliances, PF, ESI, and other statutory payments as per contract conditions. Clause 2.2 II of GEM tick. For debarment, buyer specific. And similarly, if there are With regard to services, the same thing your lordship will find at serial number 7. Non-compliance. So what is now being slipped in as a very innocuous prayer that, look, I am not being able to work. So you have been held on 3 counts. One is with regard to serial number 7. The other is serial number 2, where after issuance of show cause, you've actually forged this. Now, my lord, there's one more aspect that your lordship will kindly consider. That today, this interpretation of this clause, that's absolutely a contractual dispute. That's between me and the petitioner. Once I upload it on GEM portal, he has to then comply with, or at least go by these rules, these regulations, this policy decision that is there. This policy he is aware that this is happening in terms of the GEM portal. He is aware that once he accepts it, he has to give me these documents also apropos PF and ESI. He doesn't do that. Now, if I may hand over that paper.
And nothing is annexed to the writ petition either regarding the payment of the statutory dues, PF, ESI, nothing.
No.
You've not annexed.
Nothing. No.
There is an allegation of
Yes, Lord,
forged.
I'll come to that after.
You should have come earlier only.
Lord, I'll
because
tell
this
your
is
lordship.
one of the reasons as
I'll
to
tell
why.
your lordship why.
Let him finish.
Yes, yes.
Yes.
Well, I'll just show that table. If your lordship allows me, I'll file a short affidavit indicating this. A table tada. This is prepared by my lord, by the answering respondent. Please have a look at this last column, my lord. I'll just hand it over. Thank you.
Yes.
Remarks your lordship will see
Yes.
against 5th RA bill, TPI penalty due to non-submission of insurance, party insurance, that is there. Immediately above that, 50,000 on hold due to non-submission of service engineer's report. All this, we don't take any steps. We don't proceed against him. Turns over to the next one, my lord. And your lordship will see 8th RA bill.
Not raised.
Bidder submitted forged ESI signature documents.
No, but then the bills were not raised.
Bills were not raised. And when I asked them for it, that was the specifics, which is why I took your lordship, Manoj, and your lordship painstakingly went through that 2II. This is not a situation where he has been debarred or suspended without following the principle of natural justice. Manoj, what they now want your lordship to do is to actually substitute the decision of the authority, which is GEM and me, in a purely contractual field.
All right. What will be your submission with regard to the...
I have one additional aspect, Manoj, with regard to the maintainability of the writ in matters like this. Because my difference that has arisen between me and this petitioner is purely understanding or our interpretation, respective interpretation of this particular contract. This has no public law element involved. It's simply a commercial contractual term which is now being required.
Yes.
So this I'm taking the point of maintainability.
All right.
Desires, I'll cite the form judgment formally.
Milord, just 3 points. Milord, with the leave of Mr. Bose, if I can just address the 3 issues which have been raised, because he may not have heard it.
Yes, because I wasn't there. Whether. Yes,
But the 3 points, Milord, if your lordship just comes back to 442.
442. 451. I am at 451. The
First
description.
442. Milord, that's very interesting, Milord. And there are two points, Milord. I'll take a cue from Mr. Banerjee's submission that the court cannot be asked to substitute a decision taken by the authority.
Yes.
Is there a decision is the question that I put
It
to
is
myself.
the same thing.
Milord, now
442
442.
description is there.
It's not the same thing, Milord. Why? Because if your lordship takes the date of the creation of this incident,
yes,
this was an incident created on the self-same cause on 31st of May 2025.
Yes.
Milord, this was last modified on 23rd of June 2025.
Right.
Now, if your lordship takes the description on the left side,
yes,
same verbatim description, 3 points taken by them. The decision was then taken by GEM authority on the basis of all the documents provided by them on the same cause, which is the incident response on 23rd June 2025. Kindly, my lord, permits me to read this. Buyer has not provided the debarment order issued by competent authority, 442. competent authority of by organization, ministry, or by Department of Expenditure as per clause 2.2 of incident management policy, despite being requested for. Hence, the incident is being closed for now, and buyer may again raise fresh incident along with debarment or order issued by competent authority. My lord, this is the finding of GEM on the self-same cause at once. They file again. The next incident is what is at 451. If your lordship now takes 451.
Yes.
They create this incident on 18th of July 2025. Again, the self-same 3 points taken. But the decision that is arrived at by the authority is absolutely opposite to what has been arrived at first. On the only one ground.
Please show me that you have cleared the statutory dues, provident fund and the...
Milord, the thing is, Milord, the 2 points that they have taken. One, provident fund, and the second that forged papers were given. These are the 2 allegations.
Provident fund, ESI.
Provident fund, ESI, and forged documents.
Right.
Milord, as far as forged documents is concerned, Milord, my respectful submission would be, Milord, the GEM authority today, on the basis of one complaint and a competent authority's report of IOCL themselves, comes to a conclusion that forged documents have been submitted by. Milord, and with regards to the ESI, PSF, ESI and PF, Milord, again, Milord, what has happened is, if your lordship takes the complaint of, kindly, Milord, kindly just bears with me for one moment.
Show me that you've paid the dues.
Milord, I will have to take instructions on that. Milord, I'll come back.
No, because that
Mr. Karnani, may I just say this?
Yes, please.
Show cause, reply, order. Kindly see what were the grounds of the show cause. You cannot substitute grounds in the show cause. The show cause was given for only one reason, that the extension has not been accepted by the contract. Your ESI, provident fund, gratuity, these were never your grounds in your show cause. You have lodged a complaint with the GEM authority saying that the contractor has not accepted extension. So we have to, in my respectful submission, confine ourselves to the allegations made in the show cause. My
Page
response is simple as that.
Has been shown where the description, that is the allegation against you, are mentioned.
Page 442.
Yes, description, left hand side.
Yes, my lord.
451, the description remains the same.
Yes, my lord. Now, my lord, your lordship will kindly see the description which has been considered by the authority, the show cause. If your lordship will, I will just repeat myself once. If your lordship kindly takes 443, the second page, 443 towards the middle.
Yes.
The second paragraph, my lord, original contract terms and conditions are final binding documents to vendor sellers as per the contract special terms and conditions and contract. Completion period is 12 months from the date of handover of site, with the provision for extension of contract for 12 months, more of the same terms and conditions with the sole discretion. So what I'm respectfully submitting, accordingly, IOCL issued 1-year contract. Vendor is denying the extension. Had it been for PF, other authority, I would have given an appropriate answer. Today, I don't have the occasion to address your lordship before, because that was not even considered by GEM. GEM has suspended me for only one ground. That is, vendor is denying extension. And my lord, that is the only reason, my lord, which your lordship will find at page 451, the order of suspension. The only reason for suspending me is that I have not the extension. If there are other issues, let them raise it.
Page 451 has been placed where the fake documents and everything is mentioned.
Milord, the other issue has also been answered, Milord. Mr. Bose, if your lordship if your lordship just takes a response at 444, Milord, because this query fell from your lordship right now.
Yes.
Milord, 444, 14 June 2025, I respond to the show cause. This is a part of my writ petition. Now, Milord, after my statements, if your lordship takes 446, 2 documents are annexed with my response. Perhaps this answers both the queries. 446 is the completion certificate, which they have issued, their document after successful completion. Now, Milord, the next page, 447, is the payment confirmation receipt of ESI and Provident Fund. Milord, your lordship will take the two dates at the top. generated on 17th March 2025. Now, my lord, if your lordship turns the page, the next is for 21st April 2025. My lord, as far as these two documents which we gave to the authority in our reply letter, there is no finding whether this is a forged document, whether I have not paid the ESI and PF, and relying on the submission made by IOCL, my account is suspended. And in the completion certificate, my lord, now if your lordship takes the completion certificate once in this slide, kindly takes the completion certificate, the date of issuance of the completion certificate is after when I completed my job.
Page?
My lord, previous page, my lord, 446. This completion certificate admittedly was issued on 31st of May, 2025.
Yes.
My lord, this completion certificate, if your lordship takes, it talks about two things: name of vendor, name of the job. Now, if your lordship takes, my lord, original contract period in the middle of the table, it's a bit illegible.
Yes, yes.
My lord, original contract period 1st April 2023 to 31st March 2025. Now, my lord, actual duration of the job time 1st April 23 to 31st March 25. Job not started for extension period. Now, my lord, if your lordship comes to the bottom, last sentence at the completion certificate, contract was extended for further 12 months as per the work order terms and conditions, but job not started by the vendor for extended period. My lord, no mention of any non-compliance of any statutory document or non-compliance of payment of ESI or PF. They issue this completion certificate. When I oppose to this unilateral extension, several points come up which include these points which are not taken in the completion certificate. My lord, how can an authority...
Completion certificate is something different.
Yes, my lord.
Completion certificate has nothing to do with this.
And my lord, that payment confirmation.
Misplaced aggression. But in the writ petition,
May I just point out, apropos this, just one sentence.
Full-fledged arguments going on. I'll just respond to this. Not 450.
Before Mr. Banerjee responds, may I just show one thing? Then Mr. Banerjee, I'm sure, will have a further right to respond. I think he's already responded though. Lord, kindly, my lord, take the letter of acceptance. My lord, the extension, the discretion to give the extension is based on, my lord, one condition, which is satisfactory performance of the contract, which your lordship will find at clause 5 at page, which is a part of the letter of acceptance at page 341, the second paragraph. It starts at 340. At page 341, your lordship will find the second paragraph. Towards the middle of the paragraph, I have already read it out to your lordship initially. Your lordship will see that discretion part. The contract period may be extended by another 12 months or part thereof under same rate, terms and conditions on the sole discretion of IOCL Holdia on satisfactory performance of the contract. So, my lord, if when you have given the extension, it presupposes the fact that I have satisfactorily performed the contract. At that point of time, my lord, while giving the extension, you did not raise any of these queries. So, my lord, once you have not raised these queries because I have not accepted extension, well, can you turn back? Well, so then this becomes an arbitrary act, an act based on malafide. Could you have turned around and say, when you have offered me the extension, and just because I have an accepted extension, you come turn around and make these allegations. None of these allegations form a part of the order of the gem that because you have not been able to do X, Y, Z, that is the reason. In any event, my lord, my respectful submission before your lordship is because I have not accepted extension, that cannot be a ground for suspension. And in any event, my lord, other grounds did not form a part of the either the order of suspension or otherwise.
Yes.
And my lord, the clause at page 5, at page 341, which is clause 5 of the letter of acceptance, makes it abundantly clear that, my lord, satisfactory performance is a sine qua non for issuance of a or applying the discretion for extension.
Please come.
May I just indicate one thing? No? This thing of this not being there in the show cause is factually incorrect. Second, your lordship will not find one averment in the writ petition with regard to PF ESI forgery. That's a specific charge. It's on this 2.2, it's there. And he comes and tells the court that this is a counterblast. Not one line. You have to purge yourself if you're coming and seeking an equitable relief.
The writ petition arises out of a contract entered in between the petitioner and Indian Oil Corporation Limited within bracket IOCL. One of the terms of the contract is that the contract period may be extended by another 12 months or part thereof under same rate and terms and conditions on sole discretion of IOCL on satisfactory performance of the contractor. Step. Paragraph. After completion of the initial period of 24 months, the petitioner was offered a letter for extension of the work period for a further period of 12 months. Stop. The petitioner not agreeing to the same, the IOCL has lodged complaint before GEM, for which the GEM suspended the account of the petitioner from its portal, for which the petitioner is not in a position to participate in any further tender process. अच्छा suspended बोललाम तो from 14th August 25 to 28th September 2025. ठीक है paragraph. The reason for suspension as recorded are number one small non-compliance of service level agreement / unsatisfactory performance against a service contract, value of which is more than rupees 10 lakh. Two, no document supplied relating to submission of PF, ESI submitted to EIC. And 3, after issuing show cause notice, the seller, that is the petitioner herein, submitted forged and edited PDF files according to the petitioner, the period of contract has been extended without any offer being made by the petitioner. The petitioner is not inclined to work with IOCL. It has been submitted that the renewal cannot be unilateral. Next. It has further been submitted that the very fact that the contractual period is being extended implies that there was satisfactory performance of work. There was no allegation with regard to non-payment of statutory dues. The prayer has been made to set aside the impugned order of suspension. Paragraph. Learned advocate representing IOCL denies the submission of the petitioner. It has been submitted that there are statutory dues and no mention has been made in the government has been made in the writ petition regarding payment of the said dues. Stuff paragraph. It has been submitted that the very fact that the contract was accepted goes to show that the petitioner was agreeable to the extension. Stuff. At this stage, the petitioner cannot turn around and say that the extension will not be accepted. Stop. Next. It has been submitted that opportunity was provided to the petitioner to provide document to show payment of statutory dues, the petitioner relied upon fake documents in support of its stand. Stuff. Next. Upon here, submission has been made that the writ petition will not be maintainable as there is no public element involved herein, and the writ petition arises out of the contractual agreement entered in between the parties. Paragraph. Upon hearing the submission made on behalf of both the parties and upon perusal of the materials placed on record, it appears that there are disputed questions of facts involved. Stop. Whether the documents relied upon by the petitioner are fake or not is not evident from the documents annexed to the writ petition. Stop. IOCL asserts that the documents are fake, whereas the petitioner denies the same. Stop. Paragraph. Admittedly, the entire cause of action arises out of contractual agreement entered in between the parties. Stop. Whether the contract could have been extended on the terms and conditions accepted by the petitioner has to be adjudicated by a competent forum. Stop. Writ court will not be the appropriate court to decide the issue. Stop. In view of the above, the court refrains from exercising jurisdiction in the matter. The writ petition fails and is hereby dismissed. Stop. Dismissal of the writ petition will, however, not stand in the way of the petitioner from approaching the competent forum for adjudication of its dispute in accordance with law, if so advised.
Grateful.
Affidavit of service is
Grateful.
taken on record. Take back this document. Yes, next.
Your Lordship, I am appearing on behalf of Union of India.
Yes.
I am for the respondent number 9 and 10.
Central
my
Board
lord.
of Film Certification.
Where is the petitioner?
Your Lordship, I am for the petitioner.
Yes, please.
Your Lordship. Only one thing, my lord. In this matter, my lord, the petition has been served upon my client, who are the producer and director of the movies, on Saturday. I was engaged yesterday evening, my lord.
Last day you appeared, isn't it?
No, my lord, I have never.
No one appeared?
It is only through email I have. Today I don't even have the Vakalata. I only received email late night yesterday. If your Lordship takes up this after 2 days, well, so far as the subject matter of this writ petition is concerned, my submission would be that it has become infructuous because the movie has been released.
No, your Lordship, the writ is not infructuous because
PPFC you will be representing?
specifically sought for.
So far, my lord, my client is concerned. If your Lordship kindly comes to page 27, and information has been sought for under the Right of Information Act.
Yes.
Now that time expired. My lord, as per my instruction, no appeal has been, my lord, filed because it has not been answered.
How are you concerned? Oh, this is before you, Central Board of
Your Lordship,
Film-
I also subsequently sent them a mail. They intentionally did not answer it.
The date is 12th of August. And if your Lordship, my lord, looks into the complaint, page 36, before the officer in charge. My lord, so far this complaint goes, my lord, my lord, can be a defamatory, my lord, my respectful summon, defamatory suit or criminal matter. It doesn't have the jurisdiction under.
Your Lordship, I have approached every possible legal instrumentality and forum, but no one came to my help. Consequently, I have approached your honorable court.
What,
Your Lordship.
police in action?
No, Your Lordship,
Then
not
what?
merely police in action. Your Lordship, I am questioning them on two grounds mainly.
Yes.
First of all, what was the role of the CBFC in considering the depiction of the historical character, especially with reference to my grandfather therein, and how the depiction was evaluated by the honorable members of the CBFC. They have not yielded till date. I have repeatedly asked them, they have not yielded any answer.
Has already it has been made open to everybody, isn't it?
Yes, your Lordship.
Means-
Therein lies my claim. Your Lordship, I have specifically sought for a re-evaluation of the contents of the movie to remove, edit, or make necessary changes or cuts to the contents of the movie. Your Lordship.
Where?
Because
Which page?
Page number 19, prayer H, Your Lordship.
Where is a representation, not prayer?
Representation, Your Lordship. It is in page number 40, page number 41, Your Lordship, and yes, 40 and 41, Your Lordship.
That is the RTI application.
Yes, Your Lordship, I have specifically stated therein that I am reiterating two major questions in this regard, Your Lordship.
Question and answer is a different thing. But if you have a prayer, you have a complaint before any authority, where is your representation?
I have sent the representation through mail, Your Lordship. That is not a mere. I have reminded them that I have asked the questions not merely as posed as mere questions, but with reference to the RTI application that I had previously sent them, Your Lordship. I had also reminded them of the same, the context.
I do not see any.
Your Lordship, it is there in page 40 and 41.
For page 40, see, it is something else.
41, Your Lordship.
Regarding certain questions regard to the criteria and scrutinizing and everything, what has got that to do with the your complaint that you are making? RTI is a different thing altogether.
In RTI, I had sought some explanations, Your Lordship. I was expecting some explanations.
Very well. If no explanation has been provided, there is a provision for appeal. There is a provision for second appeal. You avail those remedies.
I had reminded them subsequently in the...
Reminder is not the end of the whole thing. The petitioner intend to obtain certain information under the Right to Information Act. Stop. The time period within which the information ought to have been provided has expired. All right, it has expired. Stop. In the event the petitioner is aggrieved by the inaction on the part of the authority to provide information within the statutory time period, then the petitioner ought to avail the remedy prescribed under the Right to Information Act. Stop. Writ petition on the same cause of action, said cause of action, will not be maintainable. Stop. In view of the above, the writ petition fails and is hereby dismissed. It will be open for the petitioner to approach the competent forum for remedy in accordance with law if so advised. Next.
Eight, my lord, I am appearing for the petitioner.
Yes.
My lord, allegation against the respondent number 12 to 21.
12 to 21?
Yes.
Who are they?
My lord, they are the private respondent who constructing their house over the water body. That, my lord, if your lordship kindly say for a moment, page 19, the nature of land.
Pukur.
My lord, that is 1414, that is Pukur. And page 20, 1414 by 2144, that is also.
Who is your other side?
My lord, I have, my lord, some respondent, private respondent received.
What about the official respondents?
My lord, official respondent, my lord, state appearing, I call her, my lord, he informed that he left the court.
Come tomorrow.
My lord, remain in its temple.
1 minute. Come tomorrow.
My lord, remain in its
same position.
Grateful, my lord.
Yes.
Password matter item number 3, I called her.
Yes.
She is saying today's resolution same not.
Resolution, she won't appear. Cannot be helped. Come tomorrow. Next.
May it please your leadership. I pray to lay for
Only the
affidavit of
number 4.
I have served. I have served.
You
the
may have
state.
served, but then Arsil. Yes, State Bank.
Censor.
What is your grievance?
Your leadership would recall at the behest, may I put the affidavit of
Yes,
service.
yes.
Your leadership would recall this is the same matter. My friend Mr. Chatterjee was mentioning the other day and craving leave to file. Your leadership, what happened? There was an auction by a secured creditor, SBI Bank. I bid. I bid.
You bid.
I bid. I become the H1 bidder.
Yes.
Now, there were notifications, public notification, both in English newspaper and Bengali newspaper. Thereafter, there were execution of sale certificate. Prior to that, there was an order under section 14 passed by the DM, South 24 Parganas, on the Property Acts. And I'll take through the facts, but just let me give the crux of the case first. The sale certificate thereafter being executed, I have been handed over possession. I have been given the various aspects of the case. I have annexed it. Thereafter, this was all in the year 2022. The sale certificate executed in the year 2022. Now, 23, 24, 25, 22nd of August, the respondent number 4 burges into my premises, comes to the 4th floor and affixes another section 14 order passed by the same DM.
Yes.
Passed by the same DM, stating that some other bank, as in the respondent number 4, is the secured creditor over the same property. Now, in this regard, first, I know there will be a question of maintainability which will be coming.
Yes.
Your leadership, here what I am praying and what I am challenging is the first aspect. Prior to proceeding, may I pray your leadership's attention to a few judgments by a division bench on a writ court, where writ is stated maintainable on what aspect. Now, as per as section 17 of the Surface Act is concerned, your leadership knows much better than me that if there has to be a 13(4) notice in accordance, in compliance, or rather in bringing into force of the 13(4) aspect, a section 14 order is sought for before the DM in order to process the 13(4) proceeding. Your leadership, neither I was a part of that transaction, neither I was given any notice whatsoever of the subsequent player seeking to be a secured creditor over the same property, which was auctioned much before them being present before the DM. Now, I pray to beg your leadership's attention to few documents which I have annexed in support of my case. Now, prior to that, so far as the question of maintainability
This respondent number 4 comes in through which financial institution?
I have no idea. In fact, the order which I have annexed.
SBI loan. SBI loan was transferred to you. And you have documents to show that. Please come. The petitioner is aggrieved by the... Yes.
Your leadership, any person, your leadership, just give me moments to clarify my case.
The petitioner is aggrieved by the steps taken by the alleged secured creditor to take over possession of the property which was purchased by the petitioner under an auction sale by the State Bank of India. Stop. The State Bank of India is not represented in court today. Stop. The respondent number 4, within bracket, Asset Reconstruction Company, within bracket, India Limited, submits upon instruction that the loan was transferred to the respondent number 4. Stop. Let further notice be issued upon the State Bank of India. আচ্ছা উপরে SBI appear করছে না, তার সাথে state is not represented.
Your Leadership, I have also served SBI. I have made them a party.
Yes.
They have also been served.
The respondent number 4 is directed to file a short report disclosing all facts and figures. Stop. Released on 22nd.
Your Leadership,
Give
perhaps
notice,
I
let
will,
notice be
but in the
served
meantime,
upon
I
the
won't be
non-appearing
bothering.
respondents.
In the meantime, I won't be bothering Your Leadership with anything more. But during this pendency, until 22nd, when the matter comes up next, there should be no coercive action against the.
What steps are you
petition.
taking?
It's a Section 14
taking
notice which
any-
has been affixed.
Very well. Section 14, they'll come with police and everything, so you'll get to know.
Much obliged, Your Leadership. Appearance zero.
Not today.
Another tender matter.
Regarding lack of territorial jurisdiction. None of the respondents are within jurisdiction, and no part of cause of action has arisen.
All right.
May I place the threat notice?
All right. Yes.
First respondent, oil, is located at Fourth Complex, Lodi Road. And the second respondent is Ministry, which is also Janpat Road, New Delhi. Now, my lord, with time, so the respondents are all outside the ministry. Kindly comes to prayer. We are challenging the prayer is at page 29.
Yes.
Prayer B, my lord, they are challenging tender dated 30th August 2025. Prayer C is also with regard to tender dated 30th August 2025. All of them are with regard to this tender. Kindly come to this tender, which is at page 407. This is with regard to a work which is to be done at the refinery of Indian Oil Corporation at Panipat in Haryana.
I am looking at it. Just see the way you have stitched up your papers. Yes.
Got annexure P90.
Yes. Right.
We find name of the organization Indian Oil Panipat Refinery. This is a tender for procurement of spares with regard to equipments of Indian Oil Corporation at Panipat Refinery. So, my lord, the entire cause of action is outside the jurisdiction. The policy, the tender, the work has to be carried out, everything is outside the jurisdiction. And in the writ petition, my lord, there is not a single statement as to how my lord has jurisdiction. Usually there is jurisdiction clause, my lord, writ petition. There is not a single line. My learned friend will show, my lord, if I have not found it. So my humble submission is that it's a very fundamental point. I need not show any judgments for it. Respondents are outside the entire cause of action, not even a part, my lord, is within the jurisdiction.
All right.
And my lord, there are other in this matter, my lord, in another judgment which was floated in respect of Panipat Refinery, a writ petition was filed in Madras High Court. Learned Singh dismissed it on the ground of territorial jurisdiction. Since the point is so fundamental, I need not cite any judgment.
Let me, very well.
It is not
same tender.
Not same tender.
All right.
Tender in this Panipat Refinery.
Panipat.
Madras High Court.
All right.
My lord will kindly. That judgment at page 2 it's referring to GEN 205B something dated 28th May 2025, which is not the subject tender, but kindly see the reason in paragraph 3. In the present case, the bid has been floated by Indian Oil, Haryana. The contract is going to be allotted at Panipat, Haryana, The first respondent is taking assistance of the second respondent for the purpose. This is not relevant. Kindly come to make the next slide. Not a semblance of cause of action arose within the jurisdiction of this High Court. That is, my lord, the High Court in Madras, my lord. Except for the fact that the petitioner is having a complex, my lord. Then, my lord, please kindly even where this court exercises extraordinary territorial jurisdiction by virtue of 226(2), a part of cause of action must have arisen within. Not a bit of cause of action has arisen within the jurisdiction of this court, and the petitioner is attempting to justify the present petition on the ground that it is an e-option.
Right. I've read it. Absolutely pat on the point. Go to give a copy.
I've got a copy.
All
He's given me.
written by them are also to the Indian Oil Corporation in Delhi, my lord. May I just indicate those pages? The first letter is at page 148. Uh, 148 is a letter written by the petitioner to respondent number 2 at Lodi Road, Delhi. And the reply given by us to the petitioner at page 247 is from headquarters, New Delhi. But there are other judgments also which see that.
It doesn't matter. Panipat you've showed already. Yes.
May I now, my lord, get as petitioner get a chance, my lord? This writ petition concerns, my lord, a tender, as also, my lord, something beyond the tender, which is, my lord, paragraph D. I pray D, my lord. Please see, my lord, page.
No, but then why beyond first? It is regarding a tender notice in respect of
It is not.
Panipat.
It is not only relating to a tender.
Page 407, the tender document has been placed. You want it in connection with that only.
No,
What
my lord,
can be done?
it goes much beyond that.
What is the
My lord,
beyond?
give me that 2 minutes, my lord.
Yes,
My learned
please.
friend took, my lord,
Yes, yes.
5 minutes. I didn't disturb her.
Hmm.
Well, I have not made any submission on the merits.
No, no, not on merits.
No, no,
Yes.
my lord, I am the petitioner. I
Yes.
could have at least explained the matter.
No, no, since this is a
No, I
regarding
understand that. I understand that. I don't like
objection.
disturbing anybody. Now, my lord, please let me give your lordship the background of this matter. I'll take 2 minutes. My lord, this is, my lord, regarding a technology which, my lord, relates to manufacture of certain pumps. There was a particular company which had this technology. This was a government company. Now, the government, my lord, had acquired the technology some 30 years ago from abroad. And this government company used to manufacture pumps and sell it to different government entities from, my lord, ONGC to Indian Oil Corporation to GAIL to everybody. Ultimately, this government company went into liquidation. But before it was liquidated, what it did was, by an open tender, it transferred the technology to, my lord, an entity called KSB Pumps. So, my lord, KSB acquired the plans, etc. And, my lord, KSB got this technology. Now, what is happening is, subsequently, KSB now contends that I am the original equipment manufacturer, which was the government company. So I, having purchased the technology, I have stepped into the shoes of this government manufacturer. So all spares to be sold to the government and all the government companies, I have a sole right to sell, which is completely contrary to law. Now I want to challenge the decision of, my lord, the government to only acquire from KSB. That's, my lord, Prayer D. Second, my lord, is
government
the tender.
means the Union of India.
Union of India. That's why I made the Union of Party.
Right.
Union of India, IOCL, BPCL.
No, BPCL is not a party.
No, not a party. Not a party because they are purchasing from the world by open tenders. But respondent number 1 is, my lord, restricted to, my lord, purchasing from, my lord, KSB. So, my lord, I have 2 parts to the writ petition. My lord, if your lordship sees, my lord, page.
It's absolutely mixing up of the causes of issues.
Yes.
It cannot be done in this manner. How can you do it? The two
Look, I am
different
I am
fashion.
challenged. No, because the tender is a result of the decision.
If challenge the tender, go to Panipat.
My lord, please have a look at page 407. Your
Yes,
lordship will see, my
407.
lord, why my lord, the challenge to the tender, my lord, tenders keep coming every day. Tomorrow there'll be
Yes.
another tender.
Right.
I am, my lord, on the decision.
Hmm.
My lord, please have a look at page 407.
Hmm.
And please, my lord, come to page 446.
Yes.
The meaningless exercise. This tender is meant for one person. This is a part of the tender document. Offer from only KSB Limited shall be considered for evaluation. Who is the proprietary bidder for the required goods in Indian Oil for required goods category? Offer received from any other bidder will be treated as unsolicited and summarily rejected. So this is, Milord, it's an eyewash of a tender. You issue a tender saying, I'll only accept bid for one person.
Please come.
Milord, may I just have 1 minute? I want to cite Lalit Kala Academy because I am within jurisdiction. The decision of the government to only purchase from KSB is, my lord, affecting me within jurisdiction. Even if, my lord, your lordship, my lord, comes to the conclusion that the tender I can't challenge here because it's published from Delhi and it is for, my lord, Panipat. My lord, the main decision, prayer D, I can press here. My lord, kindly may I come back at 2 p.m.?
No. Because Lalit Kala Academy will not save you. It may be IOCL from other refinery may accept other bidders. You never know.
No, my lord, I want to show your lordship that that is not the case.
It is only the Panipat refinery which is.
No, I am not only on Panipat.
Page
I am on the
407.
Milord, I am on the decision of this is Milord, and Milord, one tender is Milord meaningless, but all of IOCL's tenders will have this that you'll only acquire from KSB and nobody else.
No, you never know. At least nothing
that's
is
what
there
I
on
want to
record.
challenge. I know, so I want to
That is
challenge.
not on record.
Milord, I have those documents here. I'm going to show your lordship.
It was a tender matter. Court held where.
Milord, all of this is considered in Lalit Kala. Milord, Milord, please give me the, Milord, let me come back at 2 o'clock and cite Lalit Kala.
This is more specific. The Madras High Court judgment.
Milord, Madras High Court, Milord, the judgment is.
IOCL and.
Milord, Milord, may I now deal with the Madras High Court judgment?
Yes, please.
Milord, then I'll read out from Lalit Kala. Milord, kindly see paragraph 3. Bid floated by Indian Oil Corporation, contract to be allotted at Panipat. That's the only, Milord, challenge. That's the only challenge. And then it proceeds on the basis e-auction does not give jurisdiction for all high courts across India to entertain writ petitions. Court has to see where the actual cause of action has arisen. So, since bid was floated by the respondent in Haryana, it has arisen there. Now, my lord, if your lordship sees Lalit Kala takes into consideration
the affectation of rights.
Yes, so I am so what, my lord, kindly have a look at, my lord, prayer D now.
Listen, if suppose IOCL comes up with any tender where it is within the jurisdiction of this court, not Panipat or somewhere IOCL has offices over here.
Yes.
If any of the tender comes in with the same thing, purchasing from only a particular bidder,
yes,
then
but
Calcutta High Court is all
what am
right.
I attacking? I am not attacking the tender, my lord, only. I am attacking the decision of IOCL to solely acquire from KSB.
In a refinery at Panipat.
No, not for a refinery at Panipat.
This is 407.
No, please let me read. I'll just read Freddy. A writ in the nature of mandamus do issue commanding the respondent authorities to float an open tender with qualified bidders permitting participation for all in respect of BPCL pump spares.
Where is BPCL? Nothing is there.
No, but pump spare. That's a kind of a pump.
All right.
That's a kind of a pump. It's not Bharat Petroleum. So, my lord, what am I challenging? I am challenging, my lord, the...
No, sir, sorry. The The writ petition arises out of a bid document floated by GEM, floated in the GEM portal by Indian Oil Corporation Limited within bracket IOCL for an organization IOCL hyphen Panipat Refinery. Stop. The bid is limited to only one bidder. Stop. The petitioner is aggrieved by the same. Specific submission is that the entire bid document is an eyewash as the organization has already named the bidder in the tender document. Stop. The decision-making process to obtain material from only one bidder is challenged. Paragraph. Learned advocate representing IOCL raises a preliminary objection with regard to the maintainability of the writ petition before this court. Stop. Learned counsel relies upon the order dated 24th July 2025 passed by the High Court at Madras in WP number such and such, wherein in respect of a similar bid floated by IOCL for a contract to be allotted at Panipat, Haryana stood rejected on the ground of territorial jurisdiction, on the ground of non-availability of territorial jurisdiction of the Madras High Court. Stop. Paragraph. Learned advocate representing the petitioner submits that the writ petition is not particularly against the tender floated for the Panipat refinery. Stop. The affectation of right of the petitioner within the jurisdiction of this court has been highlighted for the purpose of maintaining the writ petition within the jurisdiction of this court. Stop. Upon hearing the parties and on perusal of the documents, it appears that the tender is floated for the IOCL Panipat refinery. Stop. There is nothing on record to show that similar clauses restricting bidders, restricting only one, restricting the contract, restricting the tender to only one bidder was floated within the jurisdiction of this court. Stop. The work will be required by IOCL at Panipat. Stop. A similar issue has been decided by the Madras High Court and the writ petition stood rejected. Stop. The court is of the opinion that the petitioner does not have any cause of action to maintain a writ petition within the jurisdiction of this court. Stop. The integral part of the cause of action, that is the tender document, which has been floated for the IOCL refinery at Panipat, falls outside the territorial jurisdiction of this court. Stop. In view of the above, the court is not inclined to exercise jurisdiction in this matter. Stop. The writ petition fails and is hereby dismissed. Stop. Dismissal of the writ petition will, however, not stand in the way of the petitioner to approach the proper forum in accordance with law if so advised.
Grateful.
Since they have made allegations in we are disputing regarding the merits.
Lordship has not gone into the merits.
Be it recorded that the as the writ petition is not being entertained, the allegations made therein are deemed not to have been admitted by the parties, by the respondents.
My lord, my lord, he told me that your lordship was to direct to bring your
previous lawyer for mentioning my lord.
Why previous? You are still his lawyer, isn't it?
Him no objection
When?
because I'm unable to mention before your lord.
When did you give the no objection?
Uh,
When was the no objection given? Previously? Item number 69. Why are you mentioning now? 69 has not been called. So what? Anytime you can come and mention anything. Item 19. Has payment been made?
State is supposed to make the payment from the funds which has been allocated already.
You are for, not for the state. You are for?
Respondent number 5 and 6.
All right, I'll make it not today.
Number 1344, 1345, 1346, 1347, 1348, 1349, 1350, 1351, 1352, 1353.
I3, my lord, I am for the petition.
Yes, what is it?
My lord, pursuant to last occasion, my lord's order, they have held a meeting, and in the meeting they have
They means who?
Self-help group. We are self-help group petitioner. My lord directed the BDO and SDO to make the payment or final bill. They held a meeting, and in the meeting they passed an order, which is at
yes,
page 35 and P6.
Yes.
In pursuance of notification number 2974 MDP3H such and such dated 11/12/2015 of the Principal Secretary of the MAME Department, Government of West Bengal, is learned that maintenance allowance 1000 per month per boarder shall be given for 10 months only for an academic year. As a result, the honorarium for various posts manned by the self-help group has been sub-allotted for 10 months in a financial year from the district authority. Therefore, considering the above parameter, legitimate due of the petitioner should be settled as follows. So my due has been, they have calculated is our calculation, as per our calculation, due is 2,50,000. My lord, kindly come to page 38.
And as per the authority's calculation, it is?
Our calculation is 2,50,000.
And their calculation?
They'll calculate 78,000.
78,000.
Yes. Kindly come to page 38, annexure P7.
Yes.
This is the memo. Page 39 is the quantum of financial assistance.
Yes.
Maintenance allowance at the rate of 1,000 per month per boarder shall be given for the students staying in such a hostel to the concerned madrasa school. Now period. Maintenance allowance 1,000 per month per boarder shall be given for 10 months only, one academic year. Note, if any student stays in a hostel less than 10 months in any academic year, he will get maintenance allowance for the months for which he stays in that academic year. If any student stays in a hostel for more than 10 months, he will get maintenance allowance for 10 months only, and students residing in the hostel for less than 20 days in a month shall not be eligible for the maintenance allowance. So maintenance allowance only applicable to the boarders. We are self-help group. We are providing service. So how can they deduct our salary? How it is applicable to us? As per this memo. In this memo, there is not a single line regarding that.
Is this memo referred?
Yes.
As
Page
per
35.
Page 35.
In pursuance of notification 2974. This is the order.
2974 MD.
Fourth para. Page 35.
This is 2974 MD. 11th.
2974 MDP 3H 21 dated 11/12/2015, and page 38 is the memo.
How are you entitled to receive payment? Self-help group, you are providing
provided our
service.
service.
Under which notification will you receive payment?
No, we were appointed in 2016. We have been
Appointed. Show me your appointment
Yes.
letter. What does it say regarding payment?
Nothing.
Nothing means how?
Regarding this, my lord, kindly come to first annexure, page 16. This is the notification.
Yes. Cleaner, Kormobandhu, all these things. Consolidated remuneration not exceeding 2,000 rupees per month.
Yes. Our calculation is for the whole year. They are deducting.
How many persons?
আমাদের কতজন ছিল? সবাইকে বাড়ি করে In paragraph 15, we have stated that we provided surfeit for 65 months at the rate of 19,500.
Where from are you getting this 19,500?
Yes, it is in the
Get ready. Friday, I'll enlist it under the heading payment of dues.
Right.
None appears for the respondents. Released on Friday, 12th, under the heading payment of dues. আছে কে আছে এখানে? প্রদীপ আছে? আচ্ছা. Let notice be served upon the learned advocate representing the respondents, communicating the order of the court.
We have already served notice and let the affidavit of service be kept
Yes,
in the record.
service is taken on record. Check who is there from the GP's office.
Mr. Bhaskar Vaishya was appearing.
All right, all right. Then give further notice or intimation. At least let him remain present. Next.
Six eight, my lord, I am for the petitioner.
Yes. What is the matter?
Wait.
Yes, please.
The writ petition pardons to my lord, non-compliance, my lord, with the provisions of law, my lord, Bengal Public Demand Recovery Act. My lord, this is the second round of litigation. Beforehand, my lord, the petitioner approached this honorable court. This honorable court directed the certificate officer to dispose of the application under section 9 of the act, my lord. That has not been, my lord, done. In spite, my lord, they are, my lord, raising, claiming a huge amount towards the area due without, my lord, disposing of that application. My lord, statewide, my lord, kindly have a look to the, my lord, page, annexure P9, page 44.
Yes.
So this is the order of the earlier writ petition filed, my lord. Right, my lord, this honorable court, my lord, directed the certificate officer, my lord, page 44, my lord, at the bottom. In such circumstances, it would be appropriate to direct the certificate officer to decide the application made by the petitioner under section 9 of the Act of 1913 within a period of fortnight from the date of communication of this order. WPA is disposed of accordingly. This direction was there. My lord, thereafter, lordship can have a look, my lord, page 46, my lord, this is the communication letter. But in spite of communication, my lord, that application is still pending, has not been adjudicated by the certificate officer. In spite of, my lord, they are raising claim. My lord, originally I took loan, my lord, amounting to rupees 3,32,405 for purchasing a government flat.
No, page 49, page 22, 25th of August 2020 to demand letter for payment.
My lord?
Page 49.
Page 49, my lord. My lord, this is the, my lord, claim.
Yes.
But beforehand, my lord, in the year 2009, I filed the application under section 9. That has not been, my lord, adjudicated. That's why, my lord, I approached this honorable court on earlier occasion. My lord, kindly have a look to the provisions of law, my lord. Section 9 of, my lord, section 10 and section 9 of that, my lord, Bengal Public Demands Recovery Act 1913. My lord, kindly have a look, my lord.
From 22, what happened?
Nothing, my lord. They are claiming, they are raising, my lord, demand letter. You pay without, my lord, adjudication of that, my lord, application. That application, my lord.
Show me, please show me section 9 once.
My lord, kindly have a look, my lord. Sorry, marking is there, my lord.
Doesn't matter.
Section 9 and section 10, my lord.
Certificate, letter, evidence, application.
It has to be adjudicated, my lord. Even, my lord, in case, my lord, evidence is required. My lord, that
Is your application?
My lord, that application is at page, my lord, 37 to 42. Petitioner denied his liability.
Show case number is 121, page 37.
My lord.
Date of filing?
My lord, date of filing, my lord, it was filed in the year 2009, but my lord, date actually not, my lord, written, my lord.
2009?
2009.
When are you not paid?
No,
From
2009,
you were not
2009, this application is pending, my lord. Since, my lord, this honorable court, my lord, in the year 2021, earlier directed the certificate officer to, my lord, adjudicate my application.
What is the payment that you have made?
My lord, I have paid, my lord, kindly have a look, my lord. Page 22 to 30, my lord. All total, my lord, I paid almost, my lord, 3 lakhs. Out of, my lord, loan amount 3 lakhs 32,000.
It was in 2009, prior to 2009.
My lord, loan was taken in the year 1994.
Yes.
My lord, thereafter, my lord, the family members of the petitioner, my lord, met an car accident. That's why, my lord.
Whatever. So payment is due for quite some time.
My lord, but they, my lord, imposed interest, penal interest. Now, my lord, by virtue of this application, my lord, I, my lord, requested the, my lord, authority to consider my case. That case has not been considered by virtue of, my lord, section 9 of this, my lord, Act of 1913, my lord.
Please come.
But only my Inocus period to, my lord, consider my application, my lord.
Your consideration application is pending from 2021. Pradeep, please move from front. If it was not considered in terms of the court's order, you could have preferred contempt or something. You didn't do that. You were sitting tight, waiting for the demand to come.
No, my lord.
Huge amount is due from.
My lord, I pursued with the matter, my lord. I have several occasions, my lord. I written letter to the certificate officer. Not only, my lord, communication letter. Lordship, kindly have a look, my lord, my representation.
All right, let the board come. Let me see. The petitioner is aggrieved by the steps taken by the West Bengal Housing Board in raising demand for payment of overdue installment along with interest without disposing of the application filed by the petitioner under section 9 of the Public Demand Recovery Act 1913. None represents the state. Stop. আচ্ছা এটা পাবলিকের আগে একটা বেঙ্গল আছে let notice be served this Friday.
Monday, my lord, instead of Friday, my lord.
All right, Monday. 15 তারিখ 15th.
Develop.
Service is taken on record.
Develop.
1369, 1370, 1371, 1372, 1373, 1374, 1375, 1376, 1377, 1378.
1378. My lord, I am appearing for the response.
Nobody is there today.
Seven nine. 180, 181, 182, 173, 1384, 1385, 1386.
Petitioner is not here. Yes.
87, 1388, 1389, 1390, 1391, 1392, 1393, 1394, 1395, 1396, 1397, 1398, 1399, 1400, 1401, 1402, 1403, 1404, 1405, 1406, 1407, 1408, 1409, 1410, 1411, 1412, 1413, 1414, 1415, 1416.
Just wait. এদিকে আসুন। আপনি কি